Good morning, everyone. This is Management Audit Committee. We will start by taking roll.
Senator Ide.
Here.
Senator McCune. Here. Senator Olson. Here. Senator Rothfuss. Senator Smith. Here. Representative Lean.
Here.
Representative Locke. Present. Representative Rodriguez-Williams.
Excused.
Representative Sherwood.
Here.
Vice Chairman Larson.
Here.
Chairman Knapp.
Here.
Mr. Chairman, you have a quorum.
Thank you. Welcome, everybody. Welcome, committee. Just remind all the attendees in the audience today to please sign in if you plan on testifying. We'll start off with, yes, we'll start off with the adoption of the committee rules. Matt, if you could just give a couple sentence explanation on those rules.
I'll do that, Mr. Chairman.
Thanks.
There are standard rules that are an appendix to the joint rules of the House and Senate. And the rules say that for a joint interim committee, if they don't adopt any alternative to those rules, those are adopted at, those sample rules become the default rules of the committee. This being the Management Audit Committee, which is a little different than a joint interim committee, I don't know necessarily that you have to specifically adopt rules or not. But if you did want to have any changes to the default rules, now would be the time. And don't know if you had anything else, Mr. Chairman, but.
Thank you. Any discussion from the committee members on rules? Mr. Co-Chair.
Mr. Chairman, I guess I would ask if we are going to sponsor any bills or anything, if they should pass each chamber in here individually as in a majority, or if we want to do it as a group.
I think our standard, if we went with the adoption of the regular rules, would be a majority of the group.
Correct, Mr. Chairman. Yeah, the default rules is a majority of a quorum of the full committee. And to my knowledge, the Management Audit Committee has never gone to the other type where it would be a majority of each house. To my knowledge, the Management Audit Committee has not done that. It's just been a majority of the committee.
Okay. And I think just, I agree with you that we don't necessarily need to take a vote, but all those in favor of adopting those standard rules, say aye. 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 All those opposed? All right, motion carries. All right, first we'll start off with our major administrative rules. This is an overview of Senate File 127. Josh, if you want to take the lead on that.
Good morning, Mr. Chairman. Josh Anderson, LSO. So first, I thought I'd start off with just kind of a general overview of how the rule review process works currently in our office. So I was initially just going to do this off the cuff, but then I found this presentation we'd actually done for our law school class a couple years ago. We did a class over at the law school, and at one point we walked through the rules process, and they looked at some of the administrative rules. And so this presentation was given to them, and I thought I just would revive that here for you guys real quickly, just kind of a high level look at how we do the administrative rules currently. Then I'll walk through the bill that passed this last session, Senate File 127, and then Mr. Petrie, his group did a research paper that he will walk you through, kind of side by side, the timelines of our current process, this proposed new process, and some of the potential issues that we've identified as we've looked at that. So, Mr. Chairman, so just getting into this first document I gave you on the current rules process. So we're talking about administrative rules. These are governed by the Administrative Procedure Act, which is found at 16.3.101. These rules, when they're properly adopted, they do have the force and effect of law. When we're talking about our rules, we kind of have three different things we talk about. So the first step is a proposed rule. When an agency wants to adopt a rule, it's adopted as a proposed rule. They have to have that out there at least a minimum of 45 days to receive public comment. Then they do a final adopted rule, and that's when we do our rule review. And then a separate thing is they can also do an emergency rule, and there's certain guidelines for that. Those are limited to 120 days. They can do that rule a second time, but not more than a total of 240 days. So just getting into our rule review process, when LSO receives a proposed rule, we don't really do much analysis on it at that time, except that if it's indicated that it's a new rule, and a new rule would be the first rule in response to legislation. So if you guys pass a bill and an agency adopts a rule in direct response to that legislation, then that's considered a new rule. They have to identify that to us, and then we send a letter to the sponsor of the bill and the committee that acted on it, letting them know that that new rule is out there as a proposed rule, so that they can make comments if they want to. You will see that this process is changed in Senate File 127, where these new rules will be sent to every legislator. So then after it's a proposed rule, it's out there for at least 45 days, and then if the agency adopts it as a final rule, that's when LSO conducts their rule review, and we make a recommendation to Management Council. For emergency rules, when we get those, we don't provide a recommended action because Management Council does not specifically act on emergency rules, but we do provide a summary of what that rule is to the Management Council.
Mr. Anderson, could you give an example of emergency rules that have been done in the past, just to clarify?
I can't think of anything specific, but it does happen fairly regularly. And how it works is because the rule process takes a while, at least a minimum of 45 days, and much longer than that, actually. What agencies will do often is they'll adopt that rule as an emergency rule so that it can be effective immediately as the permanent rule is going through the adoption process. And so it is a fairly regular occurrence if it's something that the agency feels has to be implemented right away and they don't have time to wait for that regular permanent rule adoption process, which does take a while. So most of the time, and I think it might be reflected in the document that Mr. Petrie is going to go through later, but it is a fairly common thing where it is adopted as emergency rule, but that same rule is going through the permanent adoption process.
Thank you. Yes.
A quick example of that, I remember a few years ago on school facilities, the school facilities department at the time was adopting emergency rules for school facility adequacy standards as they were in parallel bringing through the school facility adequacy standards. And actually the school facilities select committee objected to the emergency rules and stopped that process as part of that process. So even that part of it we were engaged in, although I think there's less opportunity for that engagement. We just were briefed on it and said, you know, that this isn't going to do, so we inserted ourselves in that process as well.
Thank you, Senator.
Yeah, and Mr. Chairman, just to follow on with that, but I said that we don't make a specific recommendation if it's an emergency rules, we just provide a summary. But that said, if we do notice something that we would object to in a normal rule review, we will note that so that the agency has time to adopt or to respond to that. knowing that they're likely also proceeding with adoption of permanent rules at the same time. So on to the next page, when we do a review of the final rules, final adopted rules, that's required to be completed within 15 days. We actually do it, we do mailing to Management Council every Tuesday. And so usually it's less than 15 days. It's whenever that Tuesday deadline hits is when we provide those to Management Council. There is an exception if the legislature's in session, the rule review is not due until 10 days after session. When we do these reviews, we're looking at three things. Is the rule within the statutory authority? So we always will look and say, the agency is generally given in statute authority to adopt rules. And so we look at what that authority is and look to see if this rule is under what authority the legislature gave them to adopt rules. We also look at if it's within the legislative intent. So does it seem to go along with the legislative scheme that's in place? And then is it adopted in compliance with the procedural requirements? So those are set out in 16.3.101, mostly in 16.3.103. So they're required to provide a statement of principal reasons, provide notice if they're new rules. There's a bunch of timelines they have to follow, so we look at all that as well. And then it's not specifically mentioned, but of course, if we think there are any constitutional concerns with the rules, we will note those as well. We also include in our rule review a recommended action by Management Council. So Management Council then takes the rule review that we provide, and then they make a formal recommendation to the governor. And again, their recommendation is either generally to approve the rules as they were submitted, to make some amendment to those rules, or to rescind the rules. And Management Council is directed to look at those same three criteria. Are the rules within the statutory authority? Are they within legislative intent? And were they adopted in compliance with the procedures? And then finally, it's the governor takes action. So again, that Management Council action is just a recommendation to the governor on what to do. The governor has the final authority regarding the rules. And again, he can approve, amend, or rescind those rules. If Management Council has recommended an amendment or rescission of the rules, the governor is required to act in compliance with that recommendation or to file his objections to those recommendations back to the Management Council. And that has happened a few years ago. We did one set of rules where we had recommended an amendment, and the governor disagreed and provided that back to Management Council. And then Management Council on the next page did consider doing a rule nullification. So if Management Council determines a rule does not meet one or more of those criteria, and the governor disagrees and adopts the rule, council may introduce legislation in the next session to have a legislative order to prohibit implementation of that rule. If that passes, the rule is null and void.
Mr. Chairman?
Yeah.
Yes, Senator Olson.
Thank you, Mr. Anderson. So that last part is a little confusing to me. So the slide says that the governor has the final authority. So even if let's say Management Council officially objects and their recommendation is to rescind the rule, the governor can still put the rule in place and approve it. He just has to issue an objection as to why he's doing that.
Correct,
Mr. Anderson.
Mr. Chairman. So the administrative rules is an executive branch function. So Management Council and LSO's portion in that is just recommendations, but the governor still has final say on those rules. And so this rule nullification process is kind of what Management Council would do if they disagreed with the governor's action. And so they could file one of these legislative order to prohibit implementation of the rule. And then if that passes, the rule is declared null and void. I say there, has not been used, I should have said in recent history. I think the last one was 1991 that I found. The more common action that I have seen is that the next session, we would just do a normal bill that would adjust that statutory authority to adopt the rules or make it clear somehow in the statutes what the rule should be, rather than just a specific order to prohibit that specific rule. That said, like I said, Management Council did consider this a couple of years ago. Ultimately decided not to sponsor that bill. And then the agency did agree with Management Council's thoughts and adopted alternative rules that went back to where, or to address the issue. And I'd note here, Senate File 127 would make it clear that any legislator could introduce one of these legislative orders to prohibit an implementation or enforcement of a rule following the major rule analysis. So that's kind of our current process, Mr. Chairman. I'd take any questions, or if not, I'd walk into the bill.
I had one. So going through the entire process, if there was a true disagreement on a rule implementation, whether it was null or whether it wasn't, would end in what would possibly be a veto override of legislation that following year.
I mean, it could potentially, Mr. Chairman. I mean, yeah, I mean, like I said, the most common thing I've seen when we've had a disagreement on rules is we've addressed that in legislation in the following year. I don't know that I've seen that be vetoed.
All right. Any other questions? All right. Thank you.
All right, so Mr. Chairman, then just quickly walking through Senate File 127 from this past session. This was, I have passed out copies of the engrossed version, or the enrolled version, excuse me. It was Enrolled Act number 59. So you'll see the first part there, Section 1, adds a new section to statute 289109. And so that 28.9 is, those existing provisions are what we just talked about, our current rule review process. So this adds a new section requiring the Legislative Service Office to review each major rule, which is defined later in the bill, and report that review in accordance with this section. For each major rule, the Legislative Service Office shall provide a copy of the rule to each member of the legislature not later than 15 days after it's submitted, and then not later than the time specified, which later in the bill is 50 days, complete a regulatory impact analysis in accordance with subsection C. Subsection C, the regulatory impact analysis shall include a statement of need for the major rule provided by the agency, the statutory authority for the rule, an examination of alternatives to the rule, an evaluation of the costs and benefits for the major rule, and then you'll see a list of what should be included in that cost and benefit analysis. So the direct benefits accruing as a result of the rule, cost savings or financial benefits, the compliance costs, the secondary or indirect costs, the effect on state revenue, the effect on state expenditures, estimated opportunity costs, the sources consulted to complete the analysis, key assumptions made, and any other information LSO would like to provide. Upon completion of that analysis, it's to be provided to each member of the legislature and also be made available to the public. As noted before, this would be done within 50 days after the rule was submitted. Subsection F just states that Management Council may direct LSO to direct this analysis for prior adopted rules. Legislative Service Office is authorized to request information from the agency promulgating the rule. Subsection H is the definition of major rule, which is any rule designated by Management Council that will result or is likely to result in an annual impact on the economy of Wyoming of $1 million or significant adverse effects on competition, employment, investment, productivity, or innovation in the state. In Section 2, Mr. Chairman, this is some amendments to the current process. You can see there, as I noted, currently in subsection D, we provide a notice of new rules to the sponsor and to the interim committee, and also to any legislator requesting notification. This would just require LSO
Mr.
to
Chairman.
provide that notice to every legislator.
Senator Olson.
Mr. Anderson, who makes the, just backing you up just a little bit to the major rule definition, who makes the determination that, the monetary determination of the $1 million?
Mr. Anderson.
Mr. Chairman, thank you. And I think Mr. Petrie's analysis will get into this a little bit. I think that's a little bit of an open question and something we might want to flesh out as we work this. So, it does say major rule is designated by Management Council. So again, I don't know if Management Council would direct LSO to advise them of that. That's probably how it would work. But again, something we may want to clarify.
Okay.
So then, yeah, bottom of page 4 there, so we'll now be providing notice of new rules to every legislator. And then also on the top of page 5, that when we receive a notice of any rule for adoption, any proposed rule, we would also provide that notice to each legislator. Then the rest, page 5, or the middle part of page 5, there's just a conforming change. And then on the bottom of page 5 there, that's that legislative order I was talking about, where this would make clear that any legislator following that analysis of a major rule could introduce legislation for a legislative order to prohibit enforcement of the rule. Over to page 6, you can see this applies beginning July 1 of next year. Section 4 is a portion just directing this committee to study this bill and its implementation and report back to Management Council. And then there's an appropriation. So that's the bill as it passed, Mr. Chairman. I'd take any questions.
Questions from the committee? So I imagine that'll be an important triggering aspect because of that threshold, whether from a legislator or for council, to have that chicken or the egg, it's information in advance, or whether they trigger it and then the analysis begins on the threshold amount.
Correct, Mr. Chairman. And so, Mr. Petrie will get into this in his document, but that's, I think, one of the issues this committee could address is clarifying when that should occur. One of our thoughts was, as under the current process, the agencies have to tell us if it's a new rule. So one thing could be they could first identify if they think it's a major rule. Of course, we could, but that might, if we put the impetus on them to first identify that, then that might help clarify the process for everybody. So that was one of our thoughts. I think Mr. Petrie will get into that a little bit in his document.
All right. Yes, Senator,
Thank you, Mr. Chairman. Mr. Anderson, what's the process on the notification to the legislature? Is that individual email to everybody in the body, or how does that work? Thank you, Mr. Chair.
Mr. Anderson.
Mr. Chairman, I don't know if we've worked that out under the current process. I believe it's an email if that our front office sends out when we provide those notice of new rules. So I'm assuming it would follow that same or similar process. But it would be going out now for pretty much each legislator would be getting a notice of every rule that is introduced, whether or not it's a major rule. And then also a separate, I think, notification if it's a major rule or a new rule.
Any other questions?
Mr. Chairman.
Yes, Senator Olson.
Mr. Anderson, I'm just curious if this bill allocated, or rather appropriated money for 2 full-time positions. Has LSO already filled those positions?
Mr. Anderson?
I don't believe so. I'd defer to Mr. Petrie on that, as I think these would be housed within his division. But I don't believe we've hired those yet. You can certainly address that further.
Any other questions? Okay, thank you. Mr. Petrie? Good morning, sir.
Morning, Chairman, Vice Chairman, members of the committee. My name is Matt Petrie. I'm the administrator of the Research and Evaluation Division at LSO. The 2 positions that were just mentioned in the last question would actually be a part of my division. We would add those 2 positions. And just to answer your question, Senator Olson, no, we have not filled those positions yet. We really wanted to get through this first meeting, and then we'll have perhaps a better idea of what those job descriptions will look like and the classifications as well.
All right.
Mr. Chairman, what I would like to do, and a little bit of this will be a bit redundant because it will touch on some of the same topics that Mr. Anderson just touched on. The reason why is what we're trying to do here is we're trying to some degree, draw a comparison to the existing rules promulgation process, and then the changes that are brought on by passage of Senate File 127. I think that the research document, the fact sheet that you have in your packet, I think does a pretty good job of explaining those differences. We've got a timeline in there that I think is probably very helpful. And then we've got one document, it's Appendix B, that touches on some of the differences, or excuse me, some of the things that we learned from other states that have gone through a similar type of transition in their promulgation process. I'll touch on those mostly in kind of a linear fashion as you see them in your document, but I might jump around a little bit because I think that there are parts of the timeline that are certainly relevant to the broader discussion, and then also touch on some of the things that the states of Florida and Kansas have done with similar legislation. So forgive me for, I won't read verbatim to you what is in that document, but I'll just touch on some of the things and then highlight other things that we mentioned in the document that will reoccur, that will just keep coming up throughout the document. So, as Mr. Anderson indicated during this last session, the legislature passed Senate File 127, the title Administrative Rules Legislative Review. This requires the completion of economic analyses for major administrative rules, and it amends the process for legislative review and notice of rules promulgation. Mr. Anderson touched on that. Senate File 127 also requires this committee, the Management Audit Committee, to study the act and its relation to existing statutory provisions concerning the role of the legislature in the administrative rule review process and provide a report to the Management Council by December 1st of this year. And again, Mr. Anderson touched briefly on those same requirements of Senate File 127. More specifically, when we write that report for submission to the Management Council no later than December 1st, the legislation indicates that the report must include the legislature's appropriate role in overseeing administrative rules and their regulatory impact, the legislative staff required to assist in fulfilling this role, which legislative body should oversee this role when the legislature is not in session, and any statutory changes that are necessary to effectuate those report findings. So that's really what we're doing here today. In addition to our 2 subsequent meetings, we'll be finalizing what we will include in that report to the Management Council on December 1st, potentially resulting in some changes to existing statute. So on the handout that you had in your packet, one of the categories that we have to talk about is changes enacted by 2025 Senate File 127. Again, a little bit of a rehash on those things that Mr. Anderson talked about, but under existing law, the Management Council is authorized to review agency administrative rules to determine if they properly implement legislative intent, are within the scope of the agency's delegated authority, and are lawfully adopted. The Legislative Service Office Legal Division conducts a legal review of all final or adopted regular rules. You'll see the term in your handout after the word regular, non-emergency rules, and that's important because that is one of the recommendations that we'll be making a little bit later in this presentation, is a distinction between regular rules, which are permanent, and emergency rules, which are temporary. And again, Legal Division conducts that legal review and reports its findings to the Management Council within 15 days of receipt from the agency. And also under the current process, if you will, the council then submits approval or recommendations for amendment or rescission of the rule to the governor for consideration before the rule is adopted. Something that Mr. Anderson touched on, and some of the idiosyncrasies with that. And again, as Mr. Anderson indicated, if the governor does not adopt the council's recommendations and the council determines the rule is inconsistent with legislative intent or does not meet constitutional and statutory requirements, the council may introduce legislation in the next legislative session to prohibit implementation or enforcement of the rule. That too is another point that we'll touch on a little bit later in this presentation, so keep that in mind. Right now, the council, Management Council, has the authority to bring legislation in the next session if the governor moves forward with a rule that they may have recommended rejection of or some changes to. Okay, moving along. Senate File 127 requires LSO to perform an additional regulatory impact analysis of each proposed major rule, which is defined as a rule, including an emergency rule. Again, another reference to emergency rules versus just regular rules. That will have an annual impact of $1 million or more on the Wyoming economy, or will have significant adverse effects on competition, employment, investment, productivity, or innovation in the state. Keep in mind that term, significant adverse effects, because that too is something that we'll revisit here in just a few minutes. Senate File 127 does not specify a process for Management Council to designate major rules for regulatory impact analysis. This, in part, is an answer to your question, Senator Olson, that and your statement, or Chairman Knapp, that which came first, the chicken or the egg. In some cases, you're not going to know whether you're approaching that $1 million threshold until you get into it. So some of the things that we've recommended a little bit later on in the presentation are some things that could be used as kind of a filter, as kind of a screening tool to essentially put some liability, some responsibility on the agencies themselves to say, we understand that this could have some significant changes. This could cause some significant changes. But again, we'll touch on that a little bit more. Upon receipt of a major rule, LSO is required to provide the major rule to each member of the legislature within 15 days and complete a regulatory impact analysis within 50 days. Unlike the LSO legal review, the LSO regulatory impact analysis is not provided to Management Council, but instead it goes to every legislator and the public. Senate File does not provide Senate File 127 does not provide a mechanism for Management Council to make recommendations based on the LSO regulatory review to the governor prior to adoption of the proposed major rule. Rather, after reviewing the regulatory analysis, the council A joint interim committee or any legislator may introduce legislation in the next legislative session to prohibit implementation or enforcement of the rule. Again, I think this is a very important thing to note, is that this does not prevent a rule from being promulgated. It allows an opportunity to challenge that rule promulgation to some degree in the next legislative session. Currently, that ability is only with the Management Council. Under Senate File 127, it opens up that ability to question that in the next session to any individual legislator or any committee. So that's a pretty big change from Senate File 127. It is important to note the LSO legal review process and the LSO regulatory review process as enacted by Senate File 127 are two parallel but separate processes with different timelines. So they essentially start at the same time, but they follow very different paths, but they run concurrently. I might ask you to turn to Appendix A in your packet. This is, I think, a very good depiction of the existing rules process. Under the Wyoming Administrative Procedure Act and under the Management Council's current administrative rule legal review process, and then also those additional regulatory impact analysis processes and other changes required by Senate File 127. So if you're looking at this timeline, and my thanks to Jesse Schaefer and Donna Shippen on my staff who put this together, and I think got a lot of information on one page. So a pretty handy tool here, I think, that we can use going forward. You look on the left-hand side of the page, in that column to the left of the dotted line that runs down the center of the page, that's essentially our process as it stands today. So when you have a new legislation that's passed that requires a rule promulgation by an agency, agencies will need to determine whether they can just go through the regular rule process, which is lengthy, or whether, in fact, they need to promulgate emergency rules. Emergency rules are often necessary because if you have a piece of legislation that, say, passes in early part of March, but the effective date of that legislation is July 1st, an agency will not be able to have regular rules in place by July 1st. The timelines and everything that's involved in regular rules promulgation takes an absolute minimum of 130 days, and that's if everything goes swimmingly. It can extend up to $300 days for regular rules. So agencies will typically promulgate emergency rules and regular rules at the exact same time. And the language in both documents is identical. It's really just giving the agency the ability to do what they need to do come July 1st in the absence of regular rules being promulgated. The governor has that authority to give the agency the green light on those emergency rules. Regular rules obviously go through a much more extensive vetting process. The agency then works with the Attorney General's office and receives permission to proceed from the agency director and the governor, as I just indicated. Then you get into the notice period. The emergency rules, as I indicated, you'll see here next to the big downward arrow in the left-hand column. Emergency rules require the agency to proceed without notice or hearing. So again, they're skipping that public notice and that public comment period. Prior to agency adoption, agencies provide 45 days notice to the Secretary of State's office, which of course is the keeper of all rules, the Legislative Service Office, and the Attorney General's office. This also includes the public comment period, where you invite legally and you advertise in statewide newspapers the ability for members of the public to comment on those draft rules. If that public comment period brings up some relatively large concerns that can't be addressed in just communication back and forth between the agency, LSO, and the person making the comment, then of course a hearing can be required. That would occur after that 45-day public comment period. Then you see in the far left-hand column a review period, 75+ days. The agency files its final rule with the Secretary of State's office and submits it to LSO and the Attorney General's office not more than 10 days after adoption. The governor may approve rules only after receiving the Management Council's recommendation. This is the process that Mr. Anderson was talking about. Or 40 days after the rule is filed with LSO, whichever one of those two things happens sooner. And the governor must respond to the recommendation within the Management Council's recommendations within 15 days. Those are all statutory deadlines. Agencies must file their regular rules within 75 days of adoption, or the rule is not effective. They would then have to notify the Secretary of State's office, LSO, and the Attorney General's office of their rule filing within 10 days. So this gives you a feel for all of the timeframes and the deadlines that are involved in the regular rule process. Again, emergency rules put in place essentially by the governor himself. And then lastly, at the very bottom of that left-hand column on your handout, emergency rules, again, are effective when filed with the governor's concurrence. Emergency rules are only effective for 120 days. You do have the option to request an extension of emergency rules. And I can tell you from personal experience in the executive branch that if you go with emergency rules, you will almost always have to do an extension.
Mr. Petrie, I'll stop you right there. I think Representative Lean, you have a question?
Yes.
Thank you, Mr. Chairman, and thank you, Mr. Petrie. My question is, you were talking about emergency rules and regular rules happening simultaneously. Has there been an instance where the regular rules and the emergency rules come together, but then one is repealed? And has there been any confusion about implementation of that rule and then the repeal of it?
Mr. Petrie.
Mr. Chairman, Representative Lean, not to my knowledge, and I'll touch on this a little bit later in the presentation, but emergency rules, just by the nature of emergency rules, they would not be subject to repeal. They are temporary, and by the time you get to the next session, where you might have that opportunity to repeal a rule that's been implemented, those emergency rules would have already run their course. They would have already expired, if you will. Regular rule, and I think Mr. Anderson may have touched on this, in terms of repeal of an administrative rule in a subsequent legislative session. I personally am not aware of any. That doesn't mean that it hasn't happened. I think that the important thing to keep in mind is that under the example that we're working with here, where legislation passes in one session, the agency promulgates or implements emergency rules in order to get things in place by, say, July 1st, and then you're winding through the regular rules process, that the agency has already made its changes to the way that it's doing business. It's already made the changes in its operations in order to implement that statute that was passed in March of that year. And that's true all the way up to the next legislative session, where currently only the Management Council has the ability to question those rules statutorily. And now under Senate File 127, Management Council would still have that ability, but individual legislators would as well as committees. Does that answer your question? Okay, thank you. Okay, last topic, or last item there, left-hand column of your timeline. Again, emergency rules are only effective for 120 days with the option to refile once for a total of 240 days. Again, that's almost always the case. Again, because regular rules take 130 days, absolute minimum. Your emergency rules will expire, your first set of emergency rules will expire before you hit that 130-day mark. And so you almost always have to do an extension. You almost never need the full 120 days under the extension, but you do need 20 or 30 days typically. So those are just, that's essentially a description of the way that the rules process works now. If we move over to the column that's kind of in the center of your timeline, the one that with the heading LSO Administrative Rule Review, you'll see a bullet point or a topic right there in a square. Yellow highlighting indicates major rule and regulatory impact analysis review changes enacted by 2025 Senate File 127. So as we're working our way down this column, just keep in mind that, yeah, those things that you see there that are highlighted in yellow are changes that are brought on by 127. Receipt of the initial notice from the agency. LSO notifies the primary sponsor and committee under the current process. Under Senate File 127, LSO would be notifying every legislator. The next box, receipt of initial notice from agency. LSO notifies, oh, excuse me, we just touched on that one. Emergency rules are forwarded to the council for informational purposes only. They do not receive LSO legal review or council recommendations. Again, keep in mind that once the governor approves emergency rules, that gives the agency the ability to move forward with attempting to implement that legislation. Receipt of final rule. This is in that review period that exists now that's 75 days long. LSO provides notice to the primary sponsor and committee, and if it's a major rule, every legislator is basically notified of that major rule designation within 15 days. When we get a little bit further on in that review period, all final rules, LSO conducts legal review and reports findings to the council within 15 days. So that's the existing process. That's exactly what Mr. Anderson described. That is still in place. Senate File 127 did not change that. A little bit to your right, major rules. LSO conducts a regulatory impact analysis as determined by the council and shares that report with every legislator and the public within 50 days. So that is a change under Senate File 127. The regulatory impact analysis deadline of 50 days may extend past the council's 40-day deadline. Again, this is the council has 40 days to make its recommendation to the governor on the legal review of administrative rules. And then finally, the last item in that column where we see some of the changes brought on by Senate File 127, legislation to obtain a legislative order to prohibit the implementation or enforcement of the rule may be introduced in the next session by council based on legal review as it stands now, or the council, a committee, or any legislator based on the regulatory impact analysis. So again, the council retains the ability to do that, but you add in individual legislators or committees as well. I'm not really going to go into the details of the column to the far right hand of your timeline. That's really just trying to give you a flavor to kind of depict exactly the way that things unfold and the timelines that are involved. You can see that in some cases, as I mentioned earlier, for the regular rules process, it can take quite a bit of time. But at an absolute minimum, 120 days. Excuse me, 130 days. So that is, and like I said, I think that timeline is very important. What you've got in the far left-hand column reflects the existing situation, so it's a tool that you can continue to use. Depending on our conversation today and maybe our next two meetings, what you see in that center column with changes reflected in Senate File 127 could potentially change. Okay, let's talk a little bit about rules review volume. I think that this question came up when Mr. Anderson was before you. We wanted to get a flavor.
Senator Ide, you have a question?
Thank you, Mr. Chairman. Sorry to interrupt before you got started there. Just to back up on your emergency rule and regular rule over in the left-hand column, that public comment period, that 45 days, how is the general public notified of that to comment on it? What's the process there? Thank you, Mr. Chairman.
Mr. Petrie.
Mr. Chairman, Senator Ide, it's statutorily regulated, if you will. We basically have to provide legal notice, like any other legal notice, where there are requirements that it be published in newspapers with statewide circulation a certain number of times in a certain number of days. We also obviously basically put that onto LSO's website. And so those are the primary means of notifying the public. Again, if on your larger handout, there's a section there entitled Annual Rules Review Volume. We asked the Secretary of State's office, again, I mentioned earlier that when the rules promulgation is completed entirely, those rules are essentially filed with the Secretary of State's office. They are the keeper of all finalized administrative rules. So I reached out to the Secretary of State's office and just asked them for some data on the volume of rules submissions that we've seen over the past few years, and they were very gracious to dig into their system and get me some answers. In short, agencies notice and file a total of 100 to 200 rules each year. Depending on the year, these rules may comprise approximately 20 to 130 sets of emergency rules and approximately 25 to 100 sets of regular emergency rules. Keep in mind that an emergency rule will always have a corresponding set of regular rules, and so there is some overlap between those two numbers. Currently, LSO provides a legal review of all regular rules and reports their findings to the Management Council. Again, emergency rules are not subject to legal review, but are forwarded to the council for informational purposes only. I might direct you to the table in the larger document that you have that shows the volume for administrative rules. It's Table 1. You'll find it on page 3 of the information in your packet. I think pretty self-explanatory. You've got separated by fiscal year. We're looking at 2017 through 2024. Notices of intent. That's a form essentially that agencies have to file, indicating that they do intend to file rules. Final rule packets. You can see the volume there. Emergency rule packets, volume there as well. Non-substantive change forms. These are changes in rules that truly are non-substantive. They don't really change the content of the rule. You might have a punctuation error, a spelling error, something like that. And so those are truly just corrections to existing rules. And then total rule packets submitted. You will see, as you look at the numbers across that bottom row of total rule packets submitted, you'll see that the volume went up in 2020 and 2021. I don't know this for a fact, but my guess is that was relatively driven by COVID-19 and just the need to implement a lot of rules changes during that time period. You can see that it kind of peaked at that time, 2020 and 2021. And 2024, the volume there is relatively the same as 7 years earlier in 2017. So that gives you an idea of what the volume of rule submissions are. Keep in mind that rules can amount to a couple of pages. If you've got a smaller agency, a relatively small program, the changes in legislation are not great. Your rules, the content of your rules is going to be relatively small. On the other hand, you can have ones that are extensive. Department of Health just went through rules revisions driven by behavioral health redesign. And so what that required was tens and tens of pages of rules, just because of the way that they changed the system that the community mental health centers and substance abuse centers operate under. So you've got a real wide swing, a real variation in the volume of each individual rules packet. Just something else to keep in mind. Again, it is not known what proportion of the approximately 100 to 200 emergency and non-emergency rules submitted each year by agencies will be designated by Management Council to meet the definition of major rule, and thus subject to LSO regulatory review. So that kind of brings us back to that notion of how do you know it's a major rule until you get far enough into it to determine that, yes, it crosses that threshold. And we'll talk about that a little bit more. Appendix B to the report that you had in your packet, the fact sheet that you had in your packet, was just some highlights, if you will, in terms of when we looked at the states of Florida and the state of Kansas that have gone through similar exercises as what we're doing now, and some of the things that they found in implementation that we might potentially be able to learn from. Florida's is extensive, and I believe that they went through similar legislation in 2010, so they've had a chance to kind of work out the kinks and figure out exactly how things need to go. Kansas is much more recent. I believe Kansas was just last year, 2024. I'm not going to go over a great deal of detail on that report from Kansas and Florida. We do have a lot of detail if anybody is interested in it. We can certainly get that to you. The two things that I would like to touch on just real briefly that you'll find in Appendix B that I think are important to this discussion are Senate File 127. Again, it does not prevent regular rules from being promulgated. In both Kansas, I believe it's both Kansas and Florida, but at least one of those states, they actually say that a rule cannot be finalized, it cannot be implemented and promulgated until the legislature has ratified it. So they have a process where they will pass a piece of legislation that requires rules, and then the agency will go through this regulatory impact analysis, and their legislative service office will go through that. They will get all the way through that process, but the rules are still in effect in limbo. They have not been promulgated. And then those rules and that regulatory impact analysis are considered during the next session. And then the legislature has the ability to basically bless them at that point. The important point here, especially for the state of Florida, is that my guess is that the state of Florida probably has a full-time legislature. And so their ability to look at a rules packet when it's ready for them to look at it doesn't have to wait until the start of a next legislative session. So I think it's a big difference. Whether you consider a full-time legislature an advantage or a disadvantage, I will leave up to you, but that is one major distinction that I think we have, whereas again, in Wyoming, rules will be promulgated before anybody has an opportunity to challenge that in the subsequent legislative session, and that includes the Management Council. The other thing that I just wanted to point out that we learned from both Florida and Kansas is, and we'll touch on this in just a minute here, is that they exempt emergency rules from their definition of a major rule. So they're interested in those rules that become permanent. They're not really interested in questioning rules that are temporary, that agencies need to implement just to continue their operations under the new statutory requirements. So they exempt emergency rules from that regulatory impact analysis. They also, both states also exempt rules that are adopting federal standards and other rules specifically exempted by law. When we say rules adopting federal standards, what we're really talking about is if you've got a state program that has significant federal funding, if there's a change in federal rules, federal code that then calls for a subsequent change in state statute, in order to keep that federal funding, you pretty much have to follow suit. And so both states have recognized that in some cases, rules aren't necessarily driven by the agency's desire or even the legislature's desire, but are more so driven by compliance requirements realistically for federal funding. But both of those two states, Kansas and Florida, provide for that. So that's something that we might want to at least consider as well in Wyoming. Again, the only other real change I touched on, in both states, rules are suspended. Rules are basically not implementable, if you will, until they've been ratified by the legislature. But that's essentially a timing issue because they have year-round legislature, probably. So those are kind of the highlights, if you will, things that we learned from Kansas and Florida. Now let's get into kind of the meat of the discussion here this morning. Consideration of possible statutory changes to Senate File 127. This is a separate category in the document that you have in front of you. I think it starts at the bottom of page 3. Again, I'm gonna read from that to some degree, but then kind of bring us back to some of the topics we've talked about previously. As we've stated before, Senate File 127 requires the Management Audit Committee to recommend to the Management Council any necessary statutory changes to support the committee's findings regarding the appropriate role of the legislature in overseeing administrative rules and their regulatory impact. So that's that report that we owe to the Management Council on December 1st. The committee may want to consider statutory changes to address the following. These are the things that we identified through our analysis of Senate File 127, the information provided by the Secretary of State's office, and then our review of similar legislation in other states. The first one, and we'll touch on each one of these individually, but just at a high level, some of those things that you may want to consider is inclusion of emergency rules in the definition of major rule, which will require LSO to perform a regulatory impact analysis on all emergency rules as well as regular rules. So we'll ask you to think about that. The second one, the criteria for determining whether a proposed rule is a major rule. The third one, the process for determining whether a proposed rule meets the statutory criteria for a major rule. And then finally, the appropriation that was in Senate File 127. So let's jump into that first one, regulatory impact analysis of emergency rules. Management Audit Committee may want to consider amending Wyoming Statute 289-109H to remove emergency rules from the definition of major rule for the purpose of excluding emergency rules from this regulatory impact analysis. And I'll give you the rationale for asking you to at least consider that. Emergency rules are typically promulgated by agencies in response to new laws or federal regulations that take effect before the regular rulemaking process can be completed. As reflected in Appendix A, this is that timeline that we talked about. An emergency rule typically takes effect while the corresponding regular rule is made available for public comment. At this point in the process, the content is usually identical between the two sets of rules. Without considering the time needed to draft a rule prior to notifying interested parties or inviting public comment, the process for regular rulemaking takes a minimum of 130 days, as I mentioned before. Emergency rules, on the other hand, are only effective for 120 days after processing, thereby typically requiring one 120-day extension of the emergency rules to bridge the gap between when the initial set of emergency rules expires and when the regular rule becomes effective. And this is important for your state agencies because if they're operating under emergency rules, those emergency rules expire before the regular rules are fully promulgated. They're essentially acting without legal authority.
Yes, Representative Ling.
Thank you. So when you get that extension, do the emergency rules remain in place or do the regular rules take over?
Mr. Petrie.
Mr. Chairman, Representative Lean, the emergency rules continue until the regular rules are fully promulgated, and that essentially, effectively, it terminates the emergency rules. Yeah. So here's what I think you would want to focus on in terms of considering a change. To
Sorry,
Senate
Mr.
File
Chairman.
127.
Yes, Senator Olson.
Follow-up to that response. So you said if a new rule is implemented, the emergency rule terminates. What happens under the new statutory scheme if there's an emergency rule in place and then it goes through its period and then up comes the permanent rule and then we reject the permanent rule? Does the emergency rule automatically go away?
Mr. Petrie.
Well, keep in mind, I'm sorry, Chairman Knapp, Senator Olson, keep in mind that whether it's an individual legislator or a legislative committee, that you don't really have the ability to reject that rule, whether it's in its emergency form or its regular rules form, until the next legislative session. So the governor still has the ability to promulgate those regular rules and make them permanent. And then we've got the regulatory impact analysis that informs the impact to Wyoming's economy. But the results of that, and however the legislator, that individual legislator or a committee or the legislature as a whole feels about it, they won't have an opportunity to address that until the next session. And that's essentially the process that we have now, but it is much more constrained, if you will, because as it stands now, of course, anybody can propose legislation. And if there is a rule that's implemented, then, can an individual legislator or a committee propose legislation that takes that agency in a different direction at the next session? Of course they can. But in terms of passage of a set of administrative rules, the Management Council currently, under just the legal review, has the ability to make a recommendation to the governor saying, we think you should reject these rules, we think you should approve, we think you should amend. Again, the governor does not have to take that recommendation. If he chooses not to, then the Management Council can come back at the next legislative session and ask for a legislative order to basically vacate those rules, which brings you back to square one in terms of implementing the legislation that originally called for the rules. But under Senate File 127, the only thing that really changes is that you've got a broader scope of individuals that can then call for that legislative order in the subsequent legislative session to essentially reverse those rules.
So, Mr. Chairman, it seems like there's extra work for LSO to do with it when an emergency rule is included under major rules. But it seems like from our standpoint, there's very little benefit to having any type of oversight over that rule because we can't deal with it during the interim anyway. And that's when the emergency rule is probably going to come up, is when we're not in session. And the emergency rule automatically brings about a permanent rule if it's going to stay in place. That's part of the process. Right. And then we have this new oversight process over the permanent rule. Mm-hmm. So, yeah, I'm just trying to understand the benefit to even having any oversight over an emergency rule. Doesn't seem like there's much because it's likely going to expire its time before we're back in session.
Senator Olson, I agree with you. I think that, what's confusing to me and the purpose of oversight in the first place is rules typically follow legislation, not the other way around. Right. And to me, this is a separation of powers issue where we're basically making sure that rules comply with the legislation that was put in place. And as rules come up, because it may not be after our legislation is just written, it may be 3 years from there dealing with the same statute. And I think it's important for us to have some mechanism to be able to stop an emergency rule in place before so much time has passed with that rule in effect. We see that with the national government. So I think that's an issue that we need to look at and explore. So go ahead, Mr. Petrie.
Thank you, Mr. Chairman. Continuing on a little bit under that same category, regulatory impact analysis of emergency rules. And this is the part that I would ask you to consider potentially for change. By including emergency rules in the definition of major rules, LSO will potentially be required to conduct 3 regulatory impact analyses for essentially the exact same set of rules. We would have to do one for that initial set of emergency rules. We would have to do one for the extension of those emergency rules once that 120 days expires, and then again, one for the regular rules. And keep in mind that out of the gate, emergency rules and regular rules are identical. The 50-day deadline for LSO to complete the regulatory impact analysis required by Wyoming Statute 289109E would occur approximately midway through the 120-day effective period of the emergency rule. If upon receipt of the LSO regulatory analysis, the new analysis that's required under Senate File 127, a legislator has concerns with a set of emergency rules, those concerns can only be addressed in the subsequent legislative session when the emergency rules have already expired. The point there is, and I think we touched on this in my answer to a previous question, is that by including emergency rule in the definition of major rule, it's giving you the authority to question something that will no longer exist when you have the authority to question it, if that makes sense. And so I think that that's probably the rationale for both Florida and Kansas to exclude emergency rules from their definition of a major rule. It might also be worth noting that emergency rules are not subject to major rule economic impact analyses in Florida or Kansas, the 2 states that implemented similar administrative rules review requirements in 2010 and 2024 respectively. Again, I think they probably saw the same conundrum, if you will. Let's jump to the second thing that we would like the committee to consider in terms of potential changes to Senate File 127. Management Audit Committee may want to consider amending the statutory criteria for determining whether a proposed rule is a major rule. Wyoming Statute 289109H defines a major rule. That's essentially that article of Wyoming law is what was created by Senate File 127, Wyoming Statute 289109. Defines a major rule as a rule that will result in or is likely to result in one or more of the following: an annual impact on the economy of Wyoming that will result in direct or indirect costs of not less than $1 million, or significant adverse effects on competition, employment, investment, productivity, or innovation in the state, including significant adverse effects on individual industries or regions within Wyoming. So those are the 2 criteria to basically decide whether a proposed rule is a major rule. The committee may want to consider amending paragraph I as follows. That was the first of those 2 qualifiers, the first of those 2 things that determine whether a proposed rule becomes a major rule. And so the suggested language might go something like an annual impact on the economy of Wyoming that will result in direct or indirect costs of not less than $1 million in the first year following promulgation of the rule. In addition to that, the committee may also want to consider looking at that second clause that determines whether a proposed rule is a major rule. May want to consider whether paragraph or Romanet 2 to be unnecessary, since a rule that satisfies the $1 million threshold has already indicated significant adverse effects, and the need to examine additional subjective effects may be necessary. So if you satisfy criteria number 1 of $1 million, you've essentially already established that there are significant adverse effects. And so the existence of clause number 2, or Romanet number 2, if you will, may not be entirely necessary. The third item that we would ask you to consider, agency notice of major rules. Management Audit Committee may want to consider amending the statute to clarify the process for Management Council designation of a rule as a major rule. It may be beneficial to require agencies to indicate whether a proposed rule satisfies the definition of a major rule as defined in Wyoming Statute 289-109H, like the analysis agencies conduct when preparing a fiscal note as the subject matter experts. And I might ask you to just think of some of the changes that were implemented by Senate File 127 as an extension of what we do when we ask agencies to prepare fiscal notes for bills. The agency is going to tell you if there are significant costs, significant impacts to the state of Wyoming, to agencies in their fiscal note. They will also go through an administrative impact analysis to see what the more kind of granular effect is on the agency. But we ask them to do that, obviously, because when you're looking at a bill, you want to know what those impacts are. And so you ask for those fiscal impact statements ahead of time before you consider those bills. This process is a bit similar, but it occurs after the legislation has already been passed. I think the important point here is, though, that I think we still need to recognize that agencies are still subject matter experts in the programs that they operate, the programs that they administer for the state of Wyoming. So LSO, in its regulatory impact analyses, will always be dependent upon information provided by agencies to some degree. Obviously, we will fold in other stakeholders, members of the public, businesses, other entities that may be impacted by either the legislation or the subsequent rules. So I think that's an important distinction, just to keep in mind that agencies will always have a role in this process, simply because they understand their programs at a level that legislative service office staff just simply won't be able to. So then, I'm sorry.
Yes, Representative.
Thank you, Mr. Chairman, and thank you for this awesome overview. I guess just while it's on my mind, I really like the idea of agencies having some sort of cover sheet or whatever to address things in this file, but it also brings to mind some of the concerns I have with the fiscal notes that we see. Sometimes there's not enough time for that agency to complete those. And so in session, we're working with bills that don't have a complete fiscal note. That's challenging. And then the nuance in terms of impact to industry or local governments is not included in that, right? So it really is that snapshot of like, what will the effect of this be on the agency? But we don't see that at the more granular level. And so if we do move forward with this thought of putting that onus back onto the agency, I think it's worth also understanding where there are challenges with agencies providing fiscal notes on bills. So just kind of tie those two things together. Thank you.
Yes. And Vice Chairman and Representative Sherwood, I acknowledge that. I think that, fiscal notes are information that are provided prior to legislation being considered. What we're talking about here is the legislation that has already passed. The rules have been written and are being considered. And then you have this process that can then kind of flesh out those impacts on business, on individuals, members of the public. We do have, at this point, we do have an opportunity for those stakeholders that could be impacted by draft rules in the public comment period. But it's not a regulatory impact analysis. It's simply the impact that it will have on them individually, as opposed to broader. But one of the things that we thought about in terms of trying to determine whether a set of proposed rules will meet that threshold for major rules that could then be considered or reconsidered in the next legislative session, is that we simply ask agencies, there is a notice of intent form that's filed with rules by agencies when they start the rulemaking process. It accompanies every single set of rules. It's basically exactly as it sounds. The agency indicates or it states its intent in promulgating rules. Usually they're going to start off with, well, we want to be in compliance with the new legislation. But in order to do so, here's what we have to do at a more granular level, and that's why we're promulgating rules. So one way that we could, I guess, kind of draw them into the process and require their involvement, which is going to be required anyway, is to add a checkbox to that Secretary of State notice of intent form, or requiring the agency that wants to promulgate rules within its statement of reasons whether the rule is a major rule. So, and agencies, when they attempt to promulgate rules, they always have to provide a statement of reasons. And again, that is exactly what it sounds like. They have to tell us why they're doing this. Again, it's usually driven by new legislation, but what they're doing is they're making that, they're drilling down a little bit deeper into the issue and coming up with the way to actually implement what's in the legislation. So those were two recommendations. What it does is it brings in agency involvement kind of on the front end of the process, rather than starting with a regulatory impact analysis on absolutely every set of rules that hits the street, if you will, and then getting a little ways into it to determine whether it satisfied one of those two criteria, $1 million in its first year, or these significant adverse impacts. So
Can I interrupt and ask you who would decide if that could be put on the statement of a notice of intent? Is that the secretary that would put it on there? Or we would ask him to?
Mr. Vice Chairman, yes, I think we would certainly want to ask the Secretary of State for permission to modify one of their forms to accommodate our concerns. I don't know that we would necessarily get a great deal of pushback from the Secretary of State's office. I think that the Secretary of State's office, really their involvement in rules promulgation is, again, at the very tail end of the process. They're the keepers of administrative rules, but they don't have a review or an evaluation role when it comes to rules themselves. Obviously, they're concerned with the agency's legal authority and did you follow all of the steps that you needed to follow while you were promulgating rules, but the content of the rules themselves, I don't think that they have concern with.
Do you think they would this Secretary of State would actually have to do some rule changes then? Or notice?
Mr. Vice Chairman, yes. Believe it or not, there are rules on rules. I'm sure that you understand that. And the Secretary of State's office does have its rules on rules. And so they would have to amend their own rules in order to accomplish something like this, where an agency would essentially, on the front end, indicate that they feel like these draft rules satisfy the definition of a major rule.
And Mr. Chairman, if I could jump in real quick, sorry, Mr. Chairman. On that notice of intent form that the Secretary of State's office has, a lot of those requirements that are on that form are listed in statute. So if we add this to statute, the Secretary of State would conform that notice page to include that. So.
Thank you for that.
Okay, just continue on just a little bit on this item, and then I'll get to our last one. Again, adding a checkbox to the Secretary of State notice of intent form, or requiring agencies to further describe their impacts of their rules in their statement of reasons that accompanies their rules filing. Again, this would enable LSO to proactively disseminate a major rules regulatory impact analysis survey to agencies at the beginning of the public comment period. So that's the other beauty of this, if you will, this approach, is that if it is in fact a major rule, or there's a very good indication that it will be considered a major rule, we can get started on that regulatory impact analysis sooner. We don't have to wait to see whether it's crossed that threshold or not. And so I think that that probably benefits everybody to some degree. It just makes it much easier to facilitate completion of that required regulatory impact analysis within that 75-day review period that you saw on that timeline that we handed out. They're also, these practices are consistent with agency self-reporting practices successfully implemented in Florida and Kansas. So again, another thing that the two states that we found that have done something similar to this have required on the front end of the process is to essentially have agencies self-indicate whether they feel like their rules are major rules. Okay. My last topic, the last thing I'd ask you to consider in terms of potential changes to Senate File 127, Management Audit Committee may want to consider clarifying the appropriation in the report that's due to the council on December 1st. Section 5 of Senate File 127 appropriates $400,000 to LSO for the hire of not more than 2 full-time equivalent employees to perform the functions specified in the Act. The committee may want to consider clarifying the $400,000 appropriation is an annual appropriation that will be biennialized to $800,000 and then adjusted for inflation. The Senate File 127 does make this a recurring appropriation, so it will become part of essentially LSO's standard budget, if you will. But the understanding, I think, was that that was that initial appropriation was for the second year of this biennium, starting July 1st, which is the effective date of Senate File 127. And so it may be necessary to clarify that in legislation in the upcoming session, that that is an annual appropriation to be biennialized to $800,000 for each biennium. And then the committee may also want to consider that the appropriation could potentially be higher depending upon the committee's recommendation to Management Council concerning the scope of the regulatory review process. So that's another thing that's required of us to report to the Management Council on December 1st is a better idea of whether that appropriation, both in dollars and in terms of personnel, is, whether those are the right amounts, right number of additional staff, right number of funding, or right amount of funding.
Mr. Chairman.
Yes, Senator Olson.
So just to understand that, the statute or the bill itself was very specifically said $400,000 for not more than 2 full-time employees. So
Understood.
I don't think there's a question of whether it should have been biannualized, because I don't know how you could do the math on, I'm not sure. So that would be $400,000 per year for 2 employees. I think that's probably pretty high, don't you? It's your division, so give me an understanding of what you anticipate hiring out for a salary benefit full-time employee.
Mr. Petrie?
Mr. Chairman, Senator Olson, I think that $400,000 certainly sufficient for 2 positions for 1 year. What we will bring those staff in at, I think, remains to be seen. But they'll probably be relatively similar to research analysts, budget fiscal analysts in the Legislative Service Office. Keep in mind that the funding itself is not just salary, but of course benefits as well, which can add significantly to the cost. Is $400,000 sufficient for those 2? From my experience, I would say yes, it is. But only for an annual period. I think you would be hard-pressed to cover all the costs with 2 employees that are, quite frankly, probably going to require master's degrees for a 2-year period. So is $400,000 enough for 1 year? My short answer would be yes. Is it enough for 2 years? My short answer would be no.
Senator, follow up.
Thank you, Mr. Chairman. So I don't have it in front of me, but I suppose if I went back and I looked at the fiscal impact statement, it would probably break down the salary and benefits for each employee. Was there an actual estimate done? Because that's $100,000 per employee for salary and benefits per year under the current statute.
Mr. Petrie?
Mr. Chairman, Senator Olson, that is correct if you look at that $400,000 appropriation as already biennialized, $100,000 per year.
And if it's not, it would only be $50,000
Correct.
per employee, which that would not make a lot of sense.
Correct, yeah. And I think that the Legislative Service Office did not submit a fiscal impact note on Senate File 127. I believe there were two. I know that the Governor's Office submitted a fiscal impact note, and I believe the Attorney General's Office did as well. Neither one of those were incorporated into the bill, and there weren't positions appropriated for either of those two agencies. But LSO did not submit a fiscal impact note.
Yes, Senator Rothfuss. Oh, follow up? Okay, Senator.
Thank you, Mr. Chairman. No, it's my recollection that that number isn't an accident for being $400,000 per year for two employees, because if my recollection of the conversation, and I was on the conference committee and had real concerns about the bill, partly for this reason, is that these positions were supposed to be high-end economists. And the only folks that could actually do a legitimate job of providing these answers. And so they weren't intended to be, young, first job research analysts. So I don't think the 400K for 1 year was an accident. That's implementing this legislation as intended. And so it's my understanding that that's consistent with your interpretation, is that the hiring, the job descriptions would need to be advanced degree economists that were capable of doing these types of statewide evaluations and doing them authoritatively, not just back of the envelope calcs. Is that right?
Mr. Petrie, so we're looking for old, wise, bring your own calculator. Go ahead.
Yeah, that'll be the description. Bring your own.
Yeah, we won't be able to hire any more people like me for this. No, that's a very good description, I think. Just thinking about it and the way that the job descriptions are going to unfold and the classifications, it's probably going to be somewhat of a combination between research analysts that have to have incredibly good research skills and writing skills, and budget fiscal analysts like Don Richards has, because there's going to be a lot of numbers. And they're going to have a very high level of comfort with that.
Senator Ide.
Thank you, Mr. Chairman. And yeah, thanks for those questions. Those were, you're answering all the questions I had on, the qualified people, what's their background, what kind of education. Would that be full-time employees, or would that be contract people that are not coming to the office, that are just working remotely somewhere? Just a little more visual on what that looks like for those employees. Thank you, Mr. Chairman.
Administrator Petrie.
Yep. Mr. Chairman, Senator Ide, they would be full-time permanent employees. And they would be working in the office. They would not be working remote.
Mr.
right.
Chairman,
Yes,
if I
Senator
may
Olson.
go back to Senator Rothfuss. I'm curious then, because I obviously wasn't on the conference committee, but was there any discussion as to why this was a one-time appropriation as opposed to a ongoing appropriation from the standard budget?
Mr. Chairman?
Senator.
Yeah, it really was just finish out the budget. We'll have a new feed bill. We prepare our own feed bill for our own budget. And so this money would be rolled into our feed bill request, which is the appropriate way for us to do it. So we had to patch that because those funds were not available. We weren't working the feed bill, so we didn't have a means for paying for it. We actually probably had enough reserve, but 400K is substantial. So that was the intent. And then moving forward, it would be rolled into legislative feed bill as a standard budget request.
All right. And right here, I'm going to apologize to the committee and to Mr. Petrie, but we do have a conflict in our time schedule. So let's take a 5-minute break and then we'll come back to this as soon as we hear from Director Olbrich. I think he's got a meeting that he's got to get to, so we'll have him come up next after a 5-minute break. We'll come back in. Mr. Anderson, do we have Director Olbricht online? We'll move to the update on status of program evaluation.
Mr. Chairman, members of the Management Audit Committee, thanks for accommodating my schedule. I really appreciate it. Actually, I found out this morning that my first grader has a Student of the Month luncheon at 11 o'clock today.
Oh,
So,
congratulations.
well, yeah, but you would think a Student of the Month would let their dad know about the luncheon more than 4 hours before it happens. So, but I understand the committee would like a little bit of an update on the LSO program evaluation function and where we're at with that. And I will keep it brief, mainly because for those members who were on the committee 2 years ago in June of 2023, I gave an exhaustive report to that committee on the status of the program evaluation section and possible path forward for that section. Essentially, since I became director in 2016, I poached positions from the management evaluation or our program evaluation section to be able to hire personnel in other growth areas at LSO in response to legislator requests. And that was primarily within our budget fiscal division and then somewhat within our legal division. Over the last 10 years, budget fiscal due to demands from the legislature has grown from 4 full-time employees to 9 full-time employees. And that growth has come at the expense of the program evaluation staff. So in 2023, Lily Sharp, Matt Petrie's predecessor, and I put out an RFP for a group to look at what the program evaluation function at the Wyoming legislature could look like, take input from legislators, executive and judicial branch agencies, and other stakeholders, and then present a report to this committee and to the Management Council. This committee ultimately decided not to hire a consultant to do that. Instead, they asked LSO to draft 2 bills, one to hire and authorize 7 new positions at LSO at a price tag of roughly $1 million a year to restaff the program evaluation section. And in the alternative, another bill to suspend all program evaluation activities at LSO for 5 years and to sunset the program evaluation function at that time. Neither bill moved out of committee. Essentially, the status quo of no program evaluations and no program evaluation staff within LSO have occurred for the last 2 years. The last full program evaluation we did here was in 2018, and we have not undertaken one since then. We don't have any more folks in the office who are strictly program evaluators. They've all moved to research analysts who staff this committee, and the products they provide to you, research memorandums, short papers, are not a program evaluation as that term is defined within statute and what we had traditionally done at LSO. So, Mr. Chairman, I'm happy to take any questions from the committee, any requests on if this committee would like us to do more research, maybe put out another RFP, anything you would like to ask me or request for us to look into moving forward on this. Sure, happy to entertain that.
Questions from the committee? Yes, Vice Chairman.
Mr. Chairman, thank you, Director Obrecht. So the program evaluation, was that mainly like if we wanted to do some audits with agencies and such? Is that kind of what they did, or is that separate?
Director?
Mr. Chairman, so, and Co-Chairman Larson, that's a great distinction and one that really needs to be made is LSO never had a financial audit component to it. The financial audit of executive branch agencies is done through the state auditor's office. And that's through, they hire a third-party CPA firm to conduct audits of executive branch agencies and of the legislative branch. We hire that same auditor to conduct our financial audits. What these program evaluations were in-depth looks at a program to determine whether that program was being carried out as the legislature intended for it to be carried out, not whether the money was being spent according to the requirements of generally accepted accounting principles.
Follow up? And Director, I have a question. So, and because I was there at that time, historically, management audit had kind of that role. And I think the question came up in 23 of whether it continued to have that role, and if it did, if we would have the personnel to carry that function out. Do you have a preference whether you believe that that should continue to be looked at as a third-party option versus internal?
So, yeah, Mr. Chairman, and the question is whether, this was floated in 2023 as well. If you don't want to hire full-time LSO staff to conduct these program evaluations, can the Management Audit Committee, through Management Council, hire its own consultants to conduct these program evaluations? And Mr. Chairman, I really think it would require more in-depth conversation and discussion with the committee on what they wanted to do. I would say that hiring consultants would be great for evaluations that are more of a one-off. But if we wanted to completely resurrect the program evaluation function, hiring staff for LSO would be my preferred method to do that.
And I would like a little feedback from the committee on that. Whether, I think if it's a program audit where you're looking at whether a program was working the way it was meant to be, probably a third-party option is the best at hiring at that time rather than keeping staff on. But if we want this committee to serve that full function of program auditing, that's another question. So, Senator.
Mr. Chair, Director, I'm new to the committee. I'm a bit fuzzy here. So, if we want a financial audit, say of the Department of Transportation or of the Wyoming Business Council, how would we get that done? So that falls under this purview, doesn't it?
Director.
Yep, Mr. Chairman, Senator Smith, no, it never has. Never since the creation of this committee in the 1970s. The legislature itself does not do financial audits. It's not that you couldn't, that you don't likely have that authority if you wanted to. It's just that that's never been a function the legislature has undertaken. It's been done through the state auditor's office and to a lesser extent, and mainly on local government entities through the Department of Audit.
So Mr. Chair,
Senator Smith.
Mr. Director, so if I heard you correctly, we could ask that be done from this committee, correct?
No,
Director?
Mr. Chairman, what you would need to do is give yourself the statutory authority to do it through a bill, and then also appropriate funds to hire an accounting firm to act as a consultant to conduct that work.
Follow-up?
I just thought that was the role of this committee, management audit. So I'm just wondering, I just want to drill down on that. It just doesn't sound right.
And in my view, and correct me if I'm wrong, Director, is that we do get audit information from our auditor on different agencies to review. However, I think this committee's purview is programs or legislation that might not be working the way we thought it would, and to drill down into that. And as part of that, we could request information from our auditor to further look at that program. Am I off there, Director?
Mr. Chairman, no, I think you encapsulated the role of this committee very well. It has always been whether the program itself, the executive branch program, is performing as the legislature intends it to. Now that, usually has a monetary component to it, whether the funds, you're getting the bang for your buck that you expected out of that program. But it's not a true financial audit where you would go audit those funds and see if they're spent appropriately pursuant to generally accepted government accounting principles.
Any other questions? Yes, Senator Ide.
Yeah, thank you, Mr. Chairman. Mr. Obrecht, I would tend to echo Senator Smith's comments there, being new to this committee and not knowing a whole lot about what's expected of us here. It would seem that the agencies in particular that he mentioned, that would be our job to, not be the fox guarding the hen house, having a third party review some of these agencies, an accounting firm or whatever, so we understand that the math is not fuzzy math and it's math from an unbiased third party. So that's just my comments. Thank you, Mr. Chairman.
Director, do you have a comment on that?
Mr. Chairman, what I think that, I guess two comments, Senator. First, that, like I've said, the committee has just done these performance evaluations of executive branch programs for the last 50 years. But, what the committee could probably benefit from is a presentation from the state auditor's office on what they do on their financial audit of executive branch agencies. And I believe that Auditor Racinas gave that presentation to this committee, I don't know, 2021, 2022, something like that. And that would give you a good background on what the state of Wyoming historically has done for a financial audit.
Senator Rothfuss.
Thank you, Mr. Chairman. Director Obrecht, it's my understanding that most of the actual auditing was done by the Department of Audit as opposed to the auditor's office, which is a little counterintuitive, but I think that was a restructuring before I was in the legislature by about a decade. So isn't that correct that right now our Department of Audit is primarily responsible for auditing the state agencies?
Director?
Mr. Chairman, I really think probably you've got somebody right there in Casper better able to answer that question than I do.
That's probably just look across the
And again, my view of it is, we talked about, at that time when I first got on here, we talked about the value of the committee and what the committee's role is, because there was a motion to actually dissolve it. So I was like, I just got here. But I think that similar to our rules that we talked about this morning, we are a tool of management council to look at different programs and to ensure that those programs are running efficiently. And I think that benefits us in reducing subcommittees and reducing select committees that are appointed, which cost money as well, and to handle it out of this committee. So any other comments, Director?
Yeah, Mr. Chairman, that's exactly right. And I really got into this 2 years ago with the committee and the discussion is that when the program evaluation section or division and this committee started in the 1970s, we didn't have the robust interim committee schedule we do now with joint standing committees, select committees, and task forces meeting multiple times throughout the interim. The legislature wasn't set up like that. So a lot of the work that this committee did then went on to the joint interim committees. They're the ones, they don't do actual program evaluations like, LSO staff did, but they review programs of the agencies to report to them and decide whether those programs need any sort of statutory changes. That was one reason that I thought a consultant would be beneficial to come in and what should this program look like? What's it look like in 50 other states? Does it have a financial component? If that's what the legislature wants, what would that cost? And I didn't get any traction with the committee in 2023 on that suggestion, but I really do think that if this committee wants to, find ways to do program evaluations, potentially to do financial audits, the first step would be to bring in a national consultant and find out what other states do on that and what it's going to cost us to do it.
And I would say too, I believe that that's the direction of management council is for this committee to find that relevancy again, to reduce the number of select committees and reduce the number of those committees that we do end up springing up during interims that cost money. And so I think this committee has that relevancy to do that and would entertain any comments from the committee. Vice Chairman.
Mr. Chairman, I'm going to go back to Senator Smith's question on auditing of state agencies. In statute 288107, I'm seeing that it seems that this committee could do that. And I guess I'm questioning if that's a desire of the committee, what do we need to do? But it sure looks like it to me we can do a financial audit of whatever.
Yeah, Director, if we were looking at a program and of an agency and wanted to do an independent audit, that of course would be still an option, correct?
Yep. Yeah, that's correct, Mr. Chairman.
Follow up? Any other comments or questions? Yes,
Mr. Chair.
Senator Smith.
Mr. Director, so it sounds like if so this committee could vote to audit Department of Transportation or Business Council, and then it would go to the Management Council, and they could decide whether or not we did it correctly or not. Is that fair?
Director?
Mr. Chairman, Senator, if you wanted to audit, do a financial audit of an agency, what you would have to do is, we don't have the staff at LSO to do that. We don't have any financial auditing background. We don't have, our staff's busy with other tasks. We would have to hire an outside firm to do that. So you would need money to be able to do that. You don't have the ability to appropriate yourself funds. So you would need to ask Management Council for those funds.
Mr. Chair.
Yes, follow up.
Mr. Director, the two employees that we're looking to hire, what are their roles going to be here?
Director?
Mr. Chairman, Senator, that's to do those rule reviews under Senate File 127.
And I would point out too, compliance is another issue. When we have reporting issues across the state with auditing, For those that are not in compliance, we do deal with that, and what possible options we have for requiring that compliance, whether it's local governments, different taxing entities, with that as well too, so. Other questions? Okay, Director, do you have any other comments?
No, Mr. Chairman, just, again, I really appreciate you accommodating my time. And I'll be back if there's more questions the committee comes up with later today. We can discuss those, or any direction you want from LSO staff. Mr. Petrie and his staff can take those and implement them. We're certainly happy to go with whatever direction this committee and the legislature wants in this function. I think, I would just say that, the other 49 states all have a program evaluation legislative function. It's an important function. When LSO started, there were, a legal director and an evaluation director. That didn't last very long, about 5 years before it just became one director. But, we stand ready to assist whatever the committee wants to do with this, but like everything, it will require resources, either of LSO staff or of consultants to get it off the ground.
And I do think there's some overlap there too with research and Mr. Petrie, your area of being involved in that too. But I'm gonna ask you to hold on one second as we would receive public comment on this section. Is there anybody in the audience that has any public comment that they want to give? Go ahead and come up and introduce yourselves, please.
Morning, Mr. Chairman, members of the committee. Justin Chavis, Director of the Department of Audit. I have with me Rich Cummings. He's our Public Funds Administrator. We could probably answer a number of the questions that you're having. So currently for the state as a whole, so for the financial audit for the state as a whole, that runs through our office. So we put out every 4 years an RFP that says, hey, we're looking for someone to do a financial audit of the state of Wyoming and the federal single audit. So we take the bids and the proposals, we evaluate them, we select the auditor, and then the auditor performs the financial audit of the state of Wyoming as a whole. So they do the audit in accordance with GAAP. When you're talking some of the specific agencies that Senator Smith was talking about, the ones you specifically named are component units of the state of Wyoming. And so they too get their own CPA audit. So they already have an independent audit performed when it comes to compliance with GAAP. So DOT, they have a financial audit just like the state as a whole. Business Council, they have a financial audit just like the state as a whole. So, and those are done by independent CPA firms. If you're looking at a specific program and what's being spent, that would fall under our authority. We have authority to do audits of state agencies. And we have in the past, we've gotten requests from the legislature that says, hey, can you look at the spending for this program? Or we might have agencies reach out to us and say, hey, can you look at the spending for this program? So that's kind of from a financial statement audit, that's kind of how things are in terms of the state as a whole and then the component units. If you're talking smaller agencies, so the statewide audit, the state as a whole, those financial statements focus on the major agencies that are contributing to the revenues and expenditures, because there's a materiality level when you're talking financial statement audits. And so your smaller agencies may not get touched or looked at very closely in terms of the overall statewide audit. But that is something that we could then take a look at if there were concerns or questions about programs or spending for particular agencies.
And Director, the way the audits work in conjunction with GAP, if we were looking at a project or a specific agency, those tools from your office are valid because they're all independent, whether it's your audit overall or whether it's the agency's audits. They're independent sources that come in to look at that so that we're following that GAP requirement in the first place, correct?
Mr. Chairman, correct. So the ones we do, we're independent from all the other agencies or local governments. Same thing, the entities where statute requires a financial statement audit, those CPA firms as well are an independent third party.
All right, thank you. Did you have a question? Vice Chairman?
Yes, Mr. Chairman, thank you. So when was the last state audit, I guess?
Mr. Chairman, Mr. Vice Chair, so the state's financial audit is completed every year.
Oh, every year.
So every year, if you go out to SAO's website, because SAO is statutorily charged with producing the financial statements, and then the audit firm comes in and says whether or not those are accurate. And so you'll see the financial audit is done every year for the state of Wyoming, as is the federal single compliance audit.
Follow up?
Mr. Chairman, I thought I heard something about a 4-year something.
So, Mr. Chairman, Mr. Vice Chair, so we put out an RFP every 4 years. So for the independent audit of the state's financials, that's a 4-year contract. But it's conducted every year.
Senator Ide?
Yeah, thank you, Mr. Chairman. Just a couple of quick questions. The first one was you mentioned some of the smaller agencies. I don't know what that cutoff is for sure, what you consider a small agency. And number two, in the instance of, say, the Wyoming Business Council, and you say that they're audited already, how does legislature get copies of that audit? And is that, I think you said that that's a third-party outside audit. Thank you, Mr. Chairman.
Director?
Mr. Chairman, Senator Ide. So for the like WBC audit, we get copies of all the audits. So every audit that's required by statute, we end up getting a copy of. I don't know that there's, I'd have to look at statute because some statutes direct, who needs to get copies of those audits. We get copies of all of them, so we're always a source for those audits. But Business Council, I don't know if they post it on their website, but if you ask them, I'm sure they would provide a copy. But I don't know that there's any other central repository other than the ones that come to us. And I'm sorry, what was the first question?
Senator?
Mr. Chairman, the first question was, you mentioned some of the smaller agencies are exempt, so to speak, and what is, how do you define a small agency? Thank you, Mr. Chairman.
Director?
Mr. Chairman, Senator Ide, so that's going to be done by the CPA firm itself in terms of when they determine the materiality level for the financial statements and what entities might impact that. So now as part of our contract with, when we put out an RFP, we make part of that every year we give the CPA firm 3 agencies that if they're not touched as part of the financial statement audit, we still want them to go in and look at internal controls and some stuff like that. So the actual cutoff I couldn't speak to, that's going to be done by the CPA firm itself. But in general, you're looking at, SAO, STO, Health, DFS. The big agencies are the ones that are mostly touched in the statewide audit.
And just in thinking of this, it might be nice for the committee because in emails we do get I don't know if you see your emails coming through with audits in them. But it would be nice to have kind of a synopsis of all the audits that we're getting. And in our meetings to have an overview of those audits so that either way, we can look at audits as a whole and see what might need to be looked at, or we can come up with a project or a program that we want to plug in there to look at and see if we're getting an audit already as from an independent source, just as a tool to look at that. So on both ends, I think it's important to see a summary of what we're getting and if there's any anomalies in there. And likewise, when we're looking at projects, to be able to use that list to make sure that we have the tools necessary to look at a program. So,
Mr. Chair,
yes, Senator.
Director, I appreciate your information. So if I heard you right, Mr. Chair, you just requested that the audit in your purview, the director to send to the committee. Is that correct? Or
I think with what we're getting, because it is from the Department of Audit, to have a summary of all of just a list of the audits that we are getting, so that if there's anything that's missing or we have a program that we want to look at, we can use that list to kind of adjust what we're requesting. So.
Mr. Chairman, so the audits we send over to you are the ones that we complete ourselves. And one of the things we are going to start doing this year is providing the committee with kind of a summary, similar to what you're looking for, a summary of here's all the audits we did, here's issues we run into. As far as the independent CPA audits, we have the most current ones out on our website. So anybody can go out to the Department of Audit website under the Public Funds Division and see all the financial statement audits that are done for all the entities that are required to provide those to us.
Senator Smith, do you have any follow-up?
Yeah, Mr. Chair, well, we'd have to track all that down. Could we have that sent to us in an email? Yeah.
Mr. Chairman, Senator Smith, we could find a way to get it to you. It's approximately 300 audits a year, so email may not be the most efficient, but.
There are that many audits. I think you just said it was done by your department, did the main audit for the state, and then.
Director.
Mr. Chairman, Senator Smith, so the Maine State's audit is done by the CPA firm, and that audit is out on SAO's website. Audits that we conduct, as they are published, we send copies of those to Management Audit Committee, and then the CPA audits that are done for all the other governmental entities in Wyoming, those currently, we put those out on our website. If you wanted us to send those to you, we could get those to you, but that's about 300 of those a year.
In your main audit, I don't think we would want to get by, or could get by email with the volume of it, but.
So, Mr. Chair.
Yes.
Mr. Director, I was really referring to the main agencies you said do their own independent audits, like that, then they hire separate CPA firms to do that. I'd like to see those audits.
Mr. Chairman,
Director.
Senator Smith, I'm sure we can get those to you.
Okay, great, yeah.
Okay. Representative Lean, you've been very patient down there. Thank you.
Thank you, Mr. Chairman. Thank you for coming today. And you've been incredibly helpful for me every time I've asked for any audit, so thank you for that. I do have a question for you about the trust funds. How often are those audited? And can something like the Cultural Trust Fund, is that in your big programs? Is that a small program? Where does that fall?
Director.
Mr. Chairman, Representative Lean. So those are, because they're specifically outlined by statute, we do those individually. And so they have different timeframe requirements. Some of them require us to audit those on an annual basis. Some are every 2 years. And so we do those and then we put those out on our website and also provide a copy to Management Audit Committee.
Follow up? Yep. Any other questions? Yes, Senator.
Thank you, Mr. Chairman. Just real quick, what's the process of choosing the outside CPA to audit those agencies? Who selects them? Thank you, Mr. Chairman.
Director?
Mr. Chairman, Senator Ide, so for the statewide audit, we select it. For all other entities, they have a similar process where they put out a bid and then the entity who is being audited selects the auditor.
Any other follow-up?
Thank you, Mr. Chairman. Just so I'm crystal clear, so the agency, in the case of the Wyoming Business Council, would be picking their own outside third-party auditor, just so I'm clear. Thank you, Mr. Chairman.
Mr. Chairman.
Director?
Senator Ide, that is correct.
I had one question. So I know just from Campbell County's perspective, are there qualified auditors within the state, or do a lot of those audits come from outside the state?
Mr. Chairman, so there are qualified auditors in state, although I think that is becoming less. There are in-state CPA firms that are kind of pulling back from the government audit space. I'd say in general, you're starting to see where there's more demand for audits than there is supply. And so you're running into a lot of entities who are required to get CPA audits, and they're saying, we can't get anybody to take the job. And so that's, like I say, locally within Wyoming, there's kind of a pullback from some CPA firms out of the government audit space, and we're seeing entities having to start looking outside Wyoming, but even then is still challenging.
Yeah, we've seen that pullback, to be qualified, and then that time it takes to do an audit, and the resources it takes, so, yeah. All right, any other questions? Okay, thank you very much, we appreciate it. All right, are there any other members of the public that wish to speak on this? Do we have anybody online? All right, we'll move on then. Hopefully, Director Olbrich is where he's supposed to be right now, so. All right, we will move back to Mr. Petrie, if we can go ahead and come back for questions and public comment on the administrative rules in any direction from the committee. Sorry to cut you off during your presentation there. If you can regain the train of thought and we'll get back to questions.
Thank you, Mr. Chairman. Actually, your timing was perfect. I was finished with my presentation.
Okay. Do we have questions from the committee on major administrative rules?
Mr. Chair.
Yes, Senator.
Director, I had a question on the two employees. If I could just get it was just a little fuzzy to me as to what their role will be. And I know that they'll be a higher level employee with master's degrees. And if you could just expand on that a little bit, that'd be great. I appreciate that, Director.
Mr. Petrie.
Mr. Chairman, Senator Smith, their role really will be to attempt to ensure that those rules are the most appropriate way to implement legislation, and that if there are adverse impacts or costs associated with implementing legislation through an agency, that's done in a way that's, the least damaging or the most beneficial to the stakeholders, those individuals that would be affected by those rules. So what it is it truly is an analysis of whatever those impacts are, benefits, whether they're beneficial or they're detrimental to stakeholders. But it occurs after the rules have been drafted by the agency. And that's certainly the case now, because realistically, what agencies do now is they draft their rules. If those emergencies are necessary, those are implemented immediately so they can move forward with those changes in their operations. And then through the public comment period, they have an opportunity to take into consideration stakeholder input, and they can change those regular rules before they are fully promulgated. So that opportunity exists now. As I indicated earlier, though, the public comment period is truly that. It is a period of time that individuals, businesses, any kind of entity can offer some concerns, ask questions of rules. This would be a bit more of a kind of a global approach. And so it would look at it in terms of, let's consider all the stakeholders. Let's consider everyone that's impacted by promulgation of this rule, and could it have been done differently to minimize the impacts or increase the benefits?
Follow up. And maybe I overspoke earlier, and I'll give you an opportunity to respond, but I always look at LSO in its different departments, and this would be research and analysis, obviously, that we're hiring for. So when I talked about overlap before, those employees wouldn't, even though I think we'll see an uptick in rules research, those employees would be also used in other areas per your discretion in LSO, correct?
Mr. Chairman, that is correct. We would, even during the legislative session, of course, research and evaluation is the division in LSO that provides all the support for standing committees. And so those individuals brought into research and evaluation would have a role in that as well during the session. Potentially, they would have a role in supporting interim committees such as this one. But I don't know that for certain. I think that right now, with my existing staff, we have that fairly well covered. And I would think that just because of the timing of implementation of rules coming out of a legislative session, that individuals in these two positions that are appropriated under Senate File 127, this would be their busiest time of year. But yeah, I think that, we certainly try to be as flexible as we can in research and evaluation, and that's true for budget and fiscal as well as legal, that we all kind of work as a team to maximize, areas of expertise in dealing with whatever questions come up.
Okay. All right, committee, and oh, yes, Senator.
I'm sorry, Jim.
Oh, Representative Lean, sorry.
Thank you. I was just curious if you knew the history of when we gave the authority to the governor to have the final say in the rules.
Mr. Chairman, I will
Mr.
need to
Petrie.
defer to Mr. Anderson.
Mr. Anderson.
Mr. Chairman, I'm not sure, but I think it's always worked that way as far as I'm aware. It's always been an executive branch function to promulgate the rules, and then LSO and legislative review of that has, to my knowledge, kind of always been just an advisory role.
And along those lines, Representative, that's something I would like to see in a directive maybe to look at, is the Florida law kind of intrigued me, that calls for a ratification of rules before they're implemented.
Okay.
I do like that aspect in that control over that. So any other comments? Yes, Senator.
Thank you, Mr. Chairman. Sorry to keep asking questions, but how do you gauge the workload on what these two hired people, I mean, you said now's the busy time. What happens, in September? Is everybody done with their work? And just kind of get a gauge on how we understand that we need two additional employees. Thank you.
Mr. Chairman, Senator Ide, our work, and I think whether it's for the legal division, research and evaluation, or even budget fiscal, certainly is variable throughout the year. Legal division very heavily impacted by bill drafts, those items coming out of a legislative session. Research and evaluation, largely right now impacted by committee staffing, as I mentioned, but also just individual requests for research by individual legislators, legislative committees. When when we are asked a question, say by an individual legislator or by a committee, then, and we prepare that answer, we do that research, we prepare that answer, that response for them, we reply to them, but they certainly have the ability, it's their choice whether that answer remains confidential, whether it's provided to all members of the legislature, or whether it's basically provided to the public through our website. So especially in research and evaluation, what you have is you have a number of questions, requests for information analysis that occur that are not always publicly available because, again, individual legislators and committee chairs have the ability to decide whether they want that to be released publicly. But I think, as with legislation, it's variable. It's hard to predict exactly what that will be. I think that the staffing levels right now, I know that the legal division is short attorneys, and my division had a resignation or retirement, if you will, earlier this week, and so we're looking to fill that position. I think that the staffing is very appropriate right now for the number of research requests that we're asked to do. But again, it can vary greatly.
And I would say, I would commend your staff on their research that's very in-depth, very thorough and professional, so I would commend that. And I do think that this committee in particular will take advantage. I know they're kind of dedicated to rules, and that's what you're looking at in the hiring procedure, but this committee, when we do look at different programs, I think that research and analysis will be very valuable to have those people on staff, and I think we'll use up their time pretty well. So, Senator Smith.
Mr. Chair, Mr. Director, I have a quick question on something you recommended, and it was on the rules. It was 20-9-109, and it was H, Romanet 1 and 2. You recommended that we say $1 million in costs in a year, in the initial year. And I was looking at the appendix on the Florida and Kansas laws, and they have within a 5-year implementation. I was wondering, your recommendation and what they have are different, and ours just says $1 million cost. Theirs says within a 5-year implementation. You recommended within a year. Just wondering if you could clarify your thoughts on that.
Mr. Petrie?
Mr. Chairman, Senator Smith, as we saw this bill make its way through the legislative session, I think that threshold was originally $100,000 was the financial threshold for something to be considered a major rule. I think in debate, I think that it was felt that that was simply too low, that you would be pulling in a high volume of rules and classifying them as major rules just because the impact statewide was relatively low. In both Kansas and Florida, they're coming at it with roughly the same approach, but their dollar amounts differ. One thing that I think was taken into consideration during consideration of the bill was $100,000 was that threshold was simply too low. Looking at some of the other states' thresholds, I think there was also some consideration about agencies with very broad authority, and such as the Department of Environmental Quality. And virtually every rule packet that they propose could potentially exceed, would definitely exceed a $100,000 threshold. And so I think the debate during consideration of the bill kind of weighed what's the correct dollar amount. And we simply came at it from an annual perspective. We set our limit at it as an annual amount as opposed to spreading a dollar amount over a 5-year period. I think probably the only other consideration, whether this was debated or not, was, again, just staffing. Florida is going to have probably a relatively large staff for this effort. And in fact, I think it's in the state of Kansas, they actually created a position that resides in the equivalent of what Wyoming's budget department is. And basically what they do is they will look at, when they're considering whether a rule would clear that threshold for a major rule, that decision initially goes to this individual who would be a very high-level position in our budget department, and then that individual makes the initial call. Yeah, I see your analysis. I see what you're saying the impacts will be, and yes, indeed, I feel it is a major. It clears that threshold for a major rule. So my point is that I think that in the two states that we used where we found similar legislation, is that those states have much larger populations and really just have the staff to potentially look at a higher volume of rules per se, based at least relative to the state's population.
Thank you.
You're welcome.
Yes, Senator Rothfuss.
Just to address that again from kind of the discussion on the conference committee when we were working that out, two concepts. One is exactly right. I think the staff cost was the biggest priority of the limitation, where I'm honestly not sure whether two people can get through what they'll have to get through, but the discussion was that could probably happen with two people. If you went back to 200,000, I don't know how many people you would need, but it would have to be a lot more than two, because it would be every rule. And then the other aspect, which I think is important to realize, is you've got the or clause, not the and clause, for what qualifies. So your Romanet 1 is, it has an indirect cost of not less than $1 million. But the Romanet 2 is kind of the catch-all of significant adverse effects on ... which kind of allows you to, all right, well, hey, this one might be hitting around 850, or maybe we can't even quantify it, but management council feels that this is going to have a significant impact. So you point to it anyway and you have it done. And that was the thought.
Any other questions? All right, is there any other public comment on this, rules within the room or online? Nope. All right, I think what we'll do, committee, is it's Friday, and I know some of you have traveled, so I'd like to move our evaluation of executive branch agency programs up, and unless there's been somebody that's listed online or anything for that, I think we can cover that and then adjourn for the rest of the day after that. So, Senator Olson. Oh, Vice Chairman first.
Sorry, nope, go ahead, sir.
Mr. Chairman, I was wondering if I would like to discuss if we're thinking about some bills.
That was exactly what I was going to ask.
And
I think we'll cover that. So maybe after we hear this next section, when we do our overview for the day, we'll cover what bills that we might want to see move forward from any of the 8 areas, or any changes in amendments to Senate File 127 that we might see too. We'll catch all that at the end. So is that all right? Okay. All right. So we'll go forward with the evaluation of the executive branch agency programs. Mr. Petrie, you're covering that as well, right?
Thank you, Mr. Chairman. Yeah, this agenda item is one where I think the intent for this agenda item was to look at agency programs that either are no longer being operated or are no longer funded, or a combination of both. And if that's the case, then to essentially clean up statute and essentially repeal the authority for those programs if they're simply no longer being operated or no longer funded. In some cases, it can be a little bit tricky when you're trying to identify programs that are still operational or are still funded because, say, for example, some tax rebate programs on property taxes, they are not guaranteed funding on an annual or a biennial basis. The legislature has the authority to appropriate for those types of programs periodically, and I believe probably, if not annually, at least biennially. And so you have to exercise a little bit of caution when you're looking at programs just strictly from their spending. And so keeping that in mind, what we did was my staff put together a kind of a summary, if you will. It turned out to be a fairly voluminous document. But what we did was at a conversation with Kevin Hibbard, the director of the Department of Budget, and asked them if they could compile a listing for us of programs that are, that are not being operated, that do not have funding, that do not have personnel. They look at programs, and when I say program, keep in mind that I'm talking about individual programs operated by agencies. So at the Department of Health, you'll have the program that benefits the child development centers, the early intervention education program. Then you'll have the mental health and substance abuse program. Those all fall within the behavioral health division, and then that falls within the Department of Health along with 3 other major divisions. So when I say program and when individuals in the agency say programs, they're talking about very specific things, operating authority that they have. When you talk to the budget department about programs, they see them at a much higher level. They really see them at the division level. And that's because the way that agencies request funding is essentially at the division level. And then in some cases, agencies have the authority to move money between programs, similar related programs within a division. So we weren't really able to get anything from the budget division in terms of funding of programs, programs that perhaps are not operating any longer. And so we took a little bit different stab at it. And what we did was we went into every agency's budget, and there is a table at the beginning of most of the agency budget requests. It's called Table of Priorities, Departmental Priorities. And what it does, and every agency is required to provide this. So what we did was we just kind of aggregated those for every agency. When you look at those tables, it'll take, it truly asks agencies to prioritize their programs in terms, and it even asks one of the questions in that table, if this program were no longer funded, what would the impacts be? I came to LSO from the Department of Health. The Department of Health does a fantastic job of giving an explanation there. But what you will see is, yes, agencies will prioritize their programs. Let's say they have a dozen programs, and they will tell you, for our core mission of this department, this program is our highest priority. It's the one we feel is the most necessary for our mission. And then work their way down the line. So they'll go all the way from priority 1 to priority 12. And they provide number of employees, they provide funding, they give you a breakdown of that funding, whether it is state general fund money, or it is federal funds, or it is other funds, like enterprise revenue funds. And then they will also give you the number of employees. They sum all that up at the bottom of that table, so they give you grand totals for funding, funding types, employees. And so we felt like that was a fairly good start to look at this, but again, it's a voluminous report. I think it's probably somewhere in the neighborhood of 70 to 80 pages. The Department of Health alone is 30 to 35. Not that their programs are that much greater than some of the other agencies, because of course you've got agencies like Department of Transportation in there as well. But they have extensive narratives regarding every one of the programs. But that would at least be a starting point for you to consider for what you would like to do, which is to, consider programs that maybe are no longer being operated and their authority could be repealed in statute. One of the other things that we considered, though we haven't approached the governor's office about this yet, is that because what we're doing is we're looking at executive branch agencies, is asking the governor's office if we could survey state agencies to ask them, specifically ask them, of the programs that you have statutory authority to operate, which are no longer being operated, and if so, why? And, or then if we wanted to look at the list of prioritized programs that appears in the budget documents, potentially ask for a further justification. Aside from that, we don't have a great deal. We put together this compilation of Table 5, this departmental priorities table that you'll find in every agency's budget. We put that together after we had sent out the packets for this committee. I didn't include it later. I chose not to include it later because I didn't know whether you would want to pursue that avenue, because it is, there's a great deal of data there and there's a great deal of variability. But it's certainly an avenue that we can pursue if you'd like.
Any questions? I, for one, think this is a great start. I think this helps identify programs that we'd like to look at. In the case of federal monies that come down to the state and often provide grant positions for programs to start up, often we need to ask ourselves, is that a program that we would have been willing to fund ourselves if that money wasn't there? So this, I think, is a great start to have this be an active committee in looking at programs that may not be needed anymore, are no longer funded anymore, and have taken on state dollars, and just evaluating those programs to see if they're necessary or no longer needed. So any comments or questions from the committee? All right. Do we have any comments from the public on this, either here or online? No? Okay. Thank you very much. This is a great start, and as I said, your review and analysis is always thorough and complete, so.
Thank you, Chair.
All right, I think what we'll do is, now if I can hear from the committee on any bills that you would like to move forward, or any topics that you would like to move forward to the next meeting for research. I know Senator Smith, you had one on including some of those audits that we might not be getting currently, and then that summary list that we'll get from the Department of Audit. So that's one thing that's going to move forward.
Yeah, in addition, I'd like us to maybe even direct the LSO to do an official independent audit of the Department of Health, Department of Transportation, and the Wyoming Business Council. And they can go to the Management Council and see if they approve that. But I'm under the impression that this committee has a lot of leeway, and we can do a lot, and we can hold state government accountable. And so we only have 2 more meetings after this one. So we need to move. We need to act today with if we're going to implement something.
Yeah, and I agree with you. I view this as an pure oversight committee for projects and departments. So it might be, I need to know from the committee, is it a good idea to look at audits that we have currently and start there? Or do we want to pick out specific departments or agencies that we would like to see independent audits from LSO? Just which direction would you like to go with that? It can be very targeted, or it can be an overall look that then allows us to dial down. So just want to hear from members. Representative Lean.
Thank you, Chairman Knapp. I would like to start with them picking their own firms that are doing their independent analysis. I'd like to see that there's an outside influence on who's selecting who's doing their audit, so that we don't have the fox guarding the hen house.
Any other comments?
Just, Mr. Chair, just to
Senator,
clarify.
yes.
Just to clarify, Representative Lean, so you're saying that that we would direct independent audits of particular agencies? Is that what you just said? Okay, great.
Vice Chairman.
Mr. Chairman, I guess I don't know where to go on this. The audits that our Department of Audit is getting, are they not independent already? And could we request they specifically report on those? Or do you want more?
I would say, and correct me if I'm wrong, since you guys are still here, but most of them are independent audits that take place. I think some are internal within the department itself, and we can get a summary list of maybe what that breakdown is. I would say, because the concern that I have is one that Director Olbrich kind of brought up, is since we don't serve that function necessarily, we're a program, kind of oversight program function, to do audits is very, very expensive. Whether we do it internally through employees or whether we do it third party. And so to me, if it's already being done and it's independent, I think that we use those that we have in place already. If it's internally and we feel like we want independent audits done based on some agency or ones that maybe are listed that we don't do independently, I think we can do that. But what we do in that regard affects how many employees we hire in LSO or how much money we allocate to do independent audits, third party. So I think that's important. So maybe we start with a summary list of what are independent, what are internal, and then from there we can dial down and make sure that we're getting all the information that we want to view state government. Senator Smith, you have.
I'd be good with that. I do think that there are some outside agencies that are auditing state government. However, I think that those agencies select who does the audit, so it doesn't have the same weight. But we can actually address that at our next meeting and when we look at what we get.
All right. Representative Lean.
Thank you, Mr. Chairman. Could I have the Department of Audit come up for just a second and ask them a question?
If you guys could come up and answer questions. Director, thank you. Representative Lean.
Thank you for coming back up. My question is, when they are selecting CPA firms to do these outside audits, are they continuously the same firm? So you've got 2, 4, 10 years of one firm auditing the same department, or is it every audit is a separate firm?
Director.
Mr. Chairman, Representative Lean, so it depends on the entity. It could be the same audit firm that's auditing for a long time. It could be different ones, kind of just depends on the entity and the situation that they have.
And I'll speak from experience too. So take Campbell County government, for instance. You have a local accounting firm that basically does the audit, but actually we're required to reach out to a Cheyenne firm to conduct that audit as well, just to meet all the qualifications. And they would go out for bid on this, but there just was basically no reply. As you said, most CPAs are getting out of the auditing business. So they in turn did that. Well, they lost their Cheyenne firm now. So now it's Colorado firms and other firms that are bidding on it. So it's very difficult to find an auditor in the first place. And then you do bid it out to make it independent, but you have to have those qualifications as an auditor too. And some CPA firms are just flat out moving away from that. So yes, follow up. Oh.
Thank you. Thank you, Mr.
Representative
Chairman.
Sherwood.
Thank you. I think, yeah, my comments were very similar in terms of just the shortage in the state. And when my day job company went out for bids, they said, unless you are going to agree to a long-term 10 years or more, relationship with us, it is not worth it for us to take you on as a new client. So there's also that.
Any follow-up questions? Okay. All right, so I guess my direction would be, let's start with the summary list. Let's start with a summary of what we're auditing, if it's internal, if it's third party, how that third party is acquired, whether it's through bid or how, and just a brief description of that, and then we can start dialing down as to who we want to see other audits from different agencies or different outside agencies that we just want to dial down to. So if we could get that. Yes, Senator,
Thank you, Mr. Chairman. I would agree with your comments there, and I think the more detail that we have, the better. Like you said, was it put out? How long have they been auditing that particular agency? Just sort of a laundry list of details so we can kind of get our head around whether we're getting what we're asking for. Thank you.
right. Representative Lean.
Thank you, Mr. Chairman. While I have the Department of Audit here, can I switch gears and ask them about some of their forms?
Absolutely.
Okay, so, Mr. Director, thank you for coming. Your F-66 form, what we found in reviewing them and reviewing city budgets is that some of these are in GAAP form and some of them are in cash form. And I'm wondering, where is the confusion within your office, or is there confusion within your office on which ones are cash and which ones are GAAP, and making those align on the fiscal years with the audits that are being performed for things like our municipalities?
Director?
Mr. Chairman, Representative Lean, I'm going to let Rich answer that. He's does the day-to-day management of those. He was our longtime state and local audit manager. That's the section within our public funds division that administers those forms.
Thank you, Director, Director, Chairman, Representative Lean. Basically, the form itself, it just depends on what the entity's ability is, okay? So some entities, they carry their information on a cash basis, and other entities will carry their information on an accrual basis. And so they're allowed to report either way. Some entities will report on a cash basis, and some will do it that way. Some entities that do, what we look for is that they report it consistently. And if you look at those particular forms, depending on which one you're looking at, it has the ability to kind of provide explanation as to why some differences might occur. So when the form works, if you're looking at an F-66 WY2, which would be a town one, when you're looking at those, if they're reporting to us on an accrual basis, but the form itself it compares what they report on revenues and what they report on expenditures and what cash they were carrying the previous year, at the end of the previous year, and it takes all that into consideration. You may end up with a difference because of the accrual situation that's sitting in there, and then the form allows for them to provide explanation in regards to that. So there's not really a confusion within our office as to how that's being reported. What ends up happening is a lot of times some entities will provide an explanation that doesn't seem to make sense in relation to, say, when we're finding this difference, the explanation should be related to an accrual reasoning or something to that effect. And so then they'll end up getting a lot of questions back from our office going, hey, this explanation doesn't seem to make sense. What are you trying to get at? And then we work with them to try to make it more correct in that aspect. So, yeah.
Follow up?
Is there a challenge for explanations on accounts, and have any of those explanations led to the findings of embezzlement within the municipalities or townships?
I keep wanting to call you director. It's because I've been talking to my partner all day.
He's just your backup.
Yeah. Mr. Chairman, thank you, Representative Lean. I don't necessarily think that our analysis of the reported information necessarily will lead us to whether or not a fraud has occurred or if there's any type of fraud occurring. What we do look at that information though, and if there's a lot of oddities or there's a lot of questions coming from the entity or there's a lot of help that we need to provide with the entity, they do end up going into what we call our risk analysis in terms of like, okay, maybe we need to go out there and conduct an audit of that particular entity and determine, and then once we're in there and we're conducting our audit, if there's indications of, misappropriation of funds or something to that effect, we definitely will dive into it a little bit more in depth to see if it's that or if it's just, bad bookkeeping, because that can be the occurrence as well. And so if the audit does end up leading into that direction, then we start doing some consulting with like DCI or things like that and start talking about, hey, we might need to move further into that aspect. In a lot of cases, I don't want to jump right to that conclusion though, because that's kind of a hairy area to be in, because that's partly why we have the public officer training course that we put out there, or we've approved other entities to put out there, is because there's a lot of factors coming into play where people just don't understand what their role is or how they should be bookkeeping things and stuff like that. And that's kind of what we run into a lot of cases, so.
Follow up? Yes, Senator McEwen.
Thank you, Mr. Chairman. I'd kind of like to see with the programs and the list of that for the next committee meeting, and if there are stuff we need to cut.
All right. So we're talking about the executive branch agency and going off of, I guess, the fact sheet that we got from Mr. Petrie, that we can start looking at some of those programs, and if any of the committee members goes through this and sees something that you would like to bring to the next meeting for action, I think that's a good starting place to go from. Mr. Vice Chairman?
I don't think they all got that, so I need to request that.
Okay, if we could have this emailed to every member.
Mr. Chairman, absolutely, we'll get that out right away.
Okay, thank you. Any follow-up? Okay. All right. And then going back to, I think the big one too is major administrative rules. Covering that area, is there anything that anybody wants to see in the next meeting, whether it's a draft or whether it's an overview? I mentioned the ratification of rules as one thing I would like to see, versus letting a rule go into effect first and then having to deal with it the year after. To delay that or stop that, and having that be ratified for any rule changes that might occur. So are there any other things that you'd like to see, Senator McEwen?
I think I agree with what you said. I'm trying to wrap my head around this. The easiest way to get there is get rid of the emergency rules procedure, right? Am I understanding this correctly?
Mr. Petrie, maybe you should come up here for this comment too, but.
I think you want to include major on that.
Major.
Ratification. I always wondered that. Separate or not.
Yeah.
Mr. Chairman,
I think we'll come up with some questions that we can answer, and that'll help kind of dictate what we see in the next meeting, so.
Okay. Mr. Chairman, Senator McEwen, could you repeat your question, please?
I think if we go with the Florida or the Kansas model of ratification, we almost have to get rid of emergency rulemaking and just have it ratified and change the timeline. Am I understanding that correctly?
Mr. Petrie?
Mr. Chairman and Senator McEwen, you could, but the difficulty I see is that the regular rules process requires public comment. It requires time for the agency to draft those rules with the Attorney General's office. If you ratify emergency rules, you would have to do it almost instantly. Because again, emergency rules primarily are used by agencies to implement rules that are called for coming out of a legislative session. So a new bill is passed, it requires rules promulgation. So they then put together the policies and procedures, if you will, that they need to implement that law. That takes time, but I may misunderstand your question, but ratifying emergency rules, I guess, to me, implies that the legislature is approving those and their content prior to the public comment period. And if you ratify rules as soon as they're drafted, there wouldn't be any public comment period. And I guess under Senate File 127, you would still have the ability to revisit those rules in the next legislative session. But I guess I personally would caution against ratifying emergency rules, just because right now that is the governor's authority to basically approve emergency rules so that agencies can move forward with implementing new laws, while the regular rules go through, albeit a longer process, but one that involves public comment.
And I just had a question on that, because emergency rules to me would kind of be an anomaly that would happen. And I just go back to the health and safety, I guess, where the legislators basically pre-authorize the governor to act in an emergency in that case, give him a time frame of days allotted to that, where he would then have to come back to legislature to in essence ratify that in a special session, and I can't remember how long of days we give, but some of those instances are pre-done and authorized, and then have to be given oversight by the legislature to extend those.
Right.
And those are the cases I would think that emergency rules come up. I can't think of another instance where we've had a lot of emergency rules that have been put into place and then had to be looked at later. Do you have a comment on that?
Mr. Chairman, yes, I would agree with that. I think that, and I touched on this briefly in my presentation, in that emergency rules, keep in mind that emergency rules are truly temporary. They exist for 120 days. If you get an extension, they exist for up to 240 days. But they're really just necessary for the agency to do what they're statutorily required to do, usually in a lot of cases with a July 1st effective date, and it's that July following the end of the session where the bill was passed. By the time you get to the next legislative session, which is where the Management Council currently has the authority to request a legislative order, essentially vacating those rules, and what Senate File 127 would do now, giving that authority to individual legislators or committees. By the time you get to that point, the emergency rules have already expired. And are no longer in effect. They served their purpose, which was to give the agency the ability to do what it's statutorily required to do while you go through this longer vetting process for stakeholders. So I don't know if I answered your question, but.
Senator Ide.
Thank you, Mr. Chairman. Yeah, emergency rules always scare me. You lose a lot of personal and economic liberty that I've seen in the past, especially at the national level, like with COVID, and then they keep extending them when the risk is already gone. I mean, I'm kind of going out on a tangent here, but can those emergency rules continually to be extended, or is there only one extension and it's one and done? Thank you, Mr. Chairman.
Mr. Petrie.
Mr. Chairman, Senator Ide, there is just one extension. So the longest that a set of emergency rules could be in effect is 240 days. You cannot, except for those instances that Chairman Knapp just referenced, where you've got a public health emergency or something like that. An emergency rule has to be accompanied by a set of regular rules. And so, again, the purpose of the emergency rules is to give the agency the authority to do what they're required to statutorily, usually on a fairly short time frame. And then the regular rules come through in a much more considered fashion and replace those emergency rules, but absolutely limited to 240 days. And in most cases, your regular rules are going to come in somewhere between 130 and I would say 150 days. And so as soon as those regular rules are fully promulgated, then the emergency rules, if there was an extension, it expires immediately.
And I don't know if you have knowledge of it, but I think I can remember the COVID ones or the health and safety being even less than that and having less of a opportunity to re-up those for additional days. But those would be the kind of things that I think I agree with you. We want to have a very tight leash on what the executive branch can do in essence of creating rules that we have no oversight for that cause economic damage. So I would agree. But.
And it's certainly an option, and I think that to some degree Kansas and Florida have looked at this, but again, I would just like to remind everyone that especially in the state of Florida, you're going to have a legislature that essentially never adjourns. And so they have, I think, greater flexibility in considering these regulatory impact analysis as soon as they're finished, so that if they want to then, attempt a legislative order to vacate those rules, they can do it relatively quickly. In Wyoming, with the way that our legislative sessions are set up, 40 days, 1 year, 20 days the next year, you've got some time you've basically got some time where the agency has to do what it's statutorily required to do. And so they do that with emergency rules initially and then regular rules. You still have that opportunity to revisit that rule in the next legislative session, to change it or to basically reject those rules through a legislative order. But the agency has still had the ability to implement that statute in the way that they felt was best.
Mr. Chairman.
Yes, Senator Olson.
So when I just do a quick search on this, I find that Florida is a part-time legislature with 60-day sessions. But there must be, I'm wondering if maybe we just need some more research in this area to understand exactly how it is that they deal with the rule oversight process differently from how we could deal with it when we have very similar, their sessions double the size of ours because it says it's 60 days annually, whereas ours is 60 days every 2 years. But I'm just curious, maybe if we could look deeper into how Florida really manages this similar legislation.
And especially, I think, too, splitting out emergency rules, to look at that separately, because to me, that may be what we need to require with more legislation as well. But did you have a question, Vice Chairman?
Mr. Chairman, thank you. I was just going to comment on top of Senator Olson's. I see Kansas is January to May usually, so they're kind of in the same boat. What do they do? So some research on that would be good.
Okay. Very good.
I do have a suggestion on amendments.
Vice Chairman?
Mr. Chairman, I would like to suggest a bill draft on some amendments.
Sure.
And see if anybody thinks they might be okay, following what was kind of recommended on subsection H, where you define major rule. I would suggest that we delete including an emergency rule, because I think that was causing a little bit of a little bit of trouble. So that would be one part of it. The second one would be on 109H little I, inserting in the first year following promulgation of the rule. When they're doing on what they have to do an impact, an annual impact on where they have to go and look into what, when it's over $1 million. But that would be just include in the first year following promulgation of the rule. And then I had one more other suggestion.
All right.
Down on the Secretary of State notice of intent, include that there's a checkbox to the current Secretary of State notice of intent form and requiring an acknowledgement by the agency within the statement of reasons whether the rule is a major rule. I don't want the or, I want both, I think. So I had 3 items.
I don't think you want that last one.
Mr. Chairman,
Senator Olson.
on the last 2, I'm not sure, Senator, that you want those. The restriction that you placed on Romanet I
Yeah.
will make it so less rules are reviewed, makes it more stringent. And then if you get rid of the or, you're making it even more stringent, so there's even less rules that we would review. And I'm not sure that's your intent.
Probably not.
Okay.
So we're gonna add the or back in.
Yeah.
I'm not sure on the first one you mentioned.
Yeah, on the first one, Mr. Chairman, I was just curious if this committee had any appetite to lower the $1 million threshold. It started at $100,000. That was the original intent of the legislation. I don't know how we ended up with $1 million as the compromise when the bill was originally $100,000, but whoever accomplished that, good job on them. But I would be willing to entertain legislation that lowers that threshold and puts more rules under our purview.
Yeah, I would agree, somewhere in between. Economic impact is sometimes ambiguous, and you can come to that threshold, but I do think $1 million is a pretty hefty target to hit for any rule oversight, so.
Mr. Chair,
Yes, Senator.
and especially in 1 year, Senator Larson, Kansas and Florida both over at least a 5-year period, that's their threshold. So that would really make it difficult to hit, I think.
Yeah, Mr. Chairman, so that if you break that down, that Florida's basically saying 200,000 is the threshold. And I think somewhere between 100,000 and 500,000 would be a really reasonable place to start. Probably where it should have been, but it is what it is now. We have the opportunity to address it.
Yes, Senator Rothfuss.
So, well, I guess we'll see if that is a motion that's being accepted. It sounds like it is, that'll be drafted. But I'd ask you if you're changing that number to revisit the appropriation and the number of staff you need, as well as to try and get a better quantification of the number of times this will be triggered by that number, because it seems like $400,000 a year will be woefully insufficient if we don't keep this $1 million. So I just want the committee to realize that negotiation to the $1 million was based on a trade-off where I'm uncomfortable spending $400,000 a year on this bill. That's just the beginning, folks. Let's see how much money we can spend and how much government we can grow to evaluate how much we've grown government.
So, Mr. Petrie, I think I'm going to rely on you to, along with this proposed draft for next meeting, to look at that number and see if that's commensurate with the employees that we've included in that to begin with, or if that you think that would require some additional in a bill draft. So, all right. So since this is draft form, is the committee, all those in favor of moving that forward to the next meeting to take a look at, signify by saying aye. Aye.
What are we agreeing, what, Mr. Chair, what are we voting on? I'm,
Okay, so as far as I know, we had I don't know if it was in the form of a motion, but we had a proposal to move, and maybe you can identify those again since we had some feedback on the last two, what you're moving forward.
Mr. Chairman, I would move, and I think I'm going to get rid of some of it with quite a bit of the discussion there. I do think we need to delete that part of including an emergency rule in the definition of major rule.
And that's on page 3 at the bottom, right?
Yes.
H.
And then I'm going to skip the other one in the first year following promulgation of the rule. If somebody wants to say, throw out 500,000, then maybe we should throw out 500,000.
I think so.
200.
Okay,
Mr. Chair,
Senator Smith.
I actually, so if we have that many rules and policies being implemented by agencies that are triggering this, we have too much government. If we have, I mean, if we had to spend more than 400,000 to implement this, then we have too much government. So I'm for 200,000. That's my thoughts on it.
Okay, I'll put in 200,000 in that draft, and you can always change it, but I still think we need to include the other part on the Secretary of State check. There's a checkbox to the current Secretary of State notice of intent form, and/or we'll put the "or" back in, like it was suggested, requiring acknowledgement by the agency within the statement of reasons whether the rule is a major rule. So there's 3 items.
What page is it? Oh, that's just on his recommendations?
Yep.
Okay.
Page 5.
Okay. All right, so I'm still going to view this as, this is something that we want to look at as a draft to see. So all those in favor signify by saying aye. Aye. All those opposed, no? All right, that goes through for next meeting. Are there any other items that we want to look at? Representative Lean.
Mr. Chairman, I would request that we just have some history of and authority by which the governor is the final say of all rules. And if you'd like, I can give an explanation quick to the committee. Just in your Constitution on page 25, Article 5, Section 14, under examination of accounts, it says that the legislature is to do that. And as prescribed, as the legislature may prescribe. It doesn't say that the governor does that. So I would just ask LSO to draft a quick summary of where the governor's authority comes from.
Yeah, and I think that goes back to rules are a follow-up to legislation, not a driver of legislation or independent of legislation. So I agree with you on that. If we could have that.
Second.
All those in favor of having that for the next meeting signify by saying aye. 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 All those opposed? All right. So I think, Mr. Anderson, if you could give us a summary kind of what we're looking at for next meeting, and we can wrap this up.
All right, so Mr. Chairman, so just from this recent discussion here, I had, we're going to get a summary of audits from the Department of Audit, and then start looking at detail from there. We're going to do this draft related to the major rules. We're going to look also at more in depth of the process in Florida and Kansas on how they have done that with the timelines and how that might impact any timelines that we would want to change here. And then we're going to do a research product here on the history of how the rule approval process has evolved given the constitutional changes. I think that's what I had, Mr. Chairman. Was there anything I missed?
Are there any others from the committee? Senator McEwen.
Thank you, Mr. Chairman. We also want to look at some of the programs and discuss that. Thank you, Mr. Chairman.
So that'll be a review of the fact sheet once it's out to everybody from Mr. Petrie to look at starting with that to view programs that may be antiquated. So, all right. Any other issues before the committee? Any other topics or comments? All right, with that, we are adjourned. Before noon.
Good job, Mr. Chairman.
Good job.
Yeah, I really hope we bring the authority back to this committee.
Did we say we were going to put that?